Good Monday evening, everybody. How is everybody doing? Welcome back here to Let's Talk Live on the LTL Media Channel. How's everybody doing this evening? I hope everybody had an amazing weekend. And I want to continue with our theme tonight of looking back in the Karen Read case, because a lot of you haven't seen the pre-trial hearings, and I thought that it would be beneficial to go over and watch the consistency of Team Read throughout all of these proceedings. So what we're going to do is go back to the September 15th hearing, where we're going to hear about a lot of discovery and evidence that has been held back from Team Read. And you can see that the cover-up and corruption was pretty much from day one in the start of this case. So we have a long hearing to go through tonight. It's going to be about 2 hours. I'll try to speed it up as much as I can. But before I get to that, what I want to do is play the Karen Read Nightline interview. And that was probably one of the only publicly long interviews that Karen ever did. And I want to go through that as well, too, because there's a lot of interesting information in that and some talking points that Karen does talk about what happened that night at 34 Fairview. So I want to welcome everybody in. Welcome. It's good to see everybody here. And then again, tonight's theme, like we always do here on the Karen Read streams, or as much as I like to do, is that we're going to donate 25% of all donations that come in tonight to Karen Read's defense. I like to try to hit at least a goal of, let's make it $100 tonight, $100 for Karen, so we can get that over to her defense fund. And we'll get that posted up after the show. I did see a few super chats and a membership before we came in. Let's see. Clarissa, thank you so much for becoming a new YouTube member. We're going to add $5 there. And I think I saw a $20 super chat before the show kicked off. So Bukaki is next. Love the name. Says, this is our moment to stand, not sit. This is injustice has grown beyond Karen because her issues are proof of corruption. If we sit down now, while she's not on trial, it'll make it about her. This is beyond that, and that's why I've not stopped here. That's why I haven't stopped. I've continued doing this, and I was talking about this the other day. You know, I kind of felt like, oh, all right, well, you know, July 1st came, we had the mistrial. This will all probably go silent for a little while, but literally there has been new news. It's been a constant news cycle. And I'm glad, because this case needs to continuously be talked about and broken down and have conversations about. Get more people involved. Talk about this to your neighbors, your brothers, your sisters, your family. Everybody needs to know what's going on in this case and what happened in Canton, because it's people like you watching these shows that click on these videos or leave comments or subscribe to these channels. You all know the truth. You know the truth. And you'll be able to tell this story because you've sat through this, you know, over at least a year and a half now. We've close to almost a year and a half when we started hearing more about this case. So we'll get into the hearing tonight again, and we'll keep that rolling. I have a $25 super chat. Let's see. Carla says, I love your talent. Keep up the good work. Thank you so much, Carla. And if I can kindly have one of my thank you. Keeping in total. Thank you, Rogue. Appreciate that. Thank you. All right. Awesome. And I think I just had a Cash App come through. Let me just look at that. We'll keep it honest here and keep all the donations pumping out. And we had a $10 donation. I think it's on Venmo. And Kathleen, thank you so much. She said, thank you for all you do. No, thank you for watching these streams, because you make the difference. So let's go to the Nightline interview first. And if you all haven't seen this, it's actually very, very important. And let's hear Karen in, I almost said Karen. Let's hear Karen in her own words. Let's play through this. And just for anybody who wants to know, this was August 22nd, 2023.
Outside this courthouse in Canton, Massachusetts, supporters swarmed around Karen Read. Charged with murder in January 2022 death, of her boyfriend, Boston police officer John O'Keefe, Reed has strenuously denied the allegations.
I did not kill John O'Keefe. I've never harmed a hair on John O'Keefe's head.
Her defense, bare-knuckled and bold, is making national headlines. Her lawyers alleging in court documents that a fellow police officer was involved in O'Keefe's death and colluded with other people in a cover-up.
You're alleging that law enforcement officials in the state committed murder and that they're covering it up. Why would they want to be involved in this?
Because he's dead. I think things went too far. It was late. There was alcohol involved, but they're all family. And there's many of them involved.
After posting bail, Reed has spent much of the past 18 months in and out of court awaiting a trial date.
And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Prosecutors allege that Reed hit O'Keefe with her car after getting into an argument earlier in the day, leaving him to die
And this
in
is
the middle
important.
of a snowstorm in January 2022. But Reed says she had no reason to harm her boyfriend.
I would call him the patron saint of Canton. He was just very selfless, frugal, and I think you'd be hard pressed to find anyone that didn't care for John.
The couple first dated in their 20s and reconnected more than a decade later in the middle of the pandemic.
So how did you meet up again?
He had reached out to me on Facebook and he said, "Hey, blast from the past, how's things?" And when I saw his picture, his profile picture was with several young children. And then it triggered my memory that his sister and his sister's husband had passed away. And he told me, yeah, I have the kids now. I admired that. I thought that was amazing.
Soon, Reed says she became part of the family, often sleeping over at O'Keefe's house and helping take care of the kids.
He would go to work and I would stay with his niece and nephew. All of the breaks that the kids had, we did something.
But their relationship also had its struggles. Reeve says O'Keefe had been relying more on her to take care of the kids and that he criticized some of the decisions she made with them.
We had an argument on New Year's Eve. We were away on vacation and he became incoherently drunk. And I ended up ringing in the new year with his niece and nephew. John didn't come back to our room till after 3 a.m. So that was rough. I felt very much taken advantage of. He apologized profusely for what happened on New Year's Eve. And he said, if you can't get over it, then you need to spend some time at yours. I can't keep apologizing. I don't want to keep rehashing this.
A few weeks later, they were invited to meet up with some friends at the Waterfall Bar in
Very
Canton.
important here.
And there, they ran into Brian Albert, a fellow Boston police officer who Reed says O'Keefe looked up to. Albert had led the city's gang unit before commanding the Fugitive Apprehension Team. It was the elite squad responsible for taking down some of the city's most dangerous criminals and featured in the 2013 TNT show, Boston's Finest.
1 minute we're walking around, everything's fine, and then 1 minute it's not fine.
Both times I met Brian Albert, he seemed like the type of person that you'd be surprised he's out socially because he doesn't seem like he ever wants to be there.
But at the bar, Reed says there was an invitation to continue hanging out at Albert's home.
I said, can we make sure we're welcome here? Nobody extended the invite to me. I didn't hear the invite extended to you.
They drive to the Albert's house. What happens next is disputed.
So I pull at the foot of the driveway. It's snowing.
Pull at the foot of the driveway.
John has no coat on. It's windy. So I drop him off. He goes up the driveway and approaches the side door. And as I see,
She saw him go to the side door. I'm sorry, I just kind of clipped that back. Let's listen to that again.
windy. So I drop him off. He goes up the driveway and approaches the side door. And as I see him approach the door, I look down at my phone.
Reed says after about 10 minutes of waiting in her car, she became irritated that O'Keefe still hadn't gotten in touch with her. And she drove back to his home where she continued calling him.
Physically watched him go inside that house. She physically watched him go inside the house. And you know what's very interesting about this? If you look, and again, I'm not a body language expert. I just know I've worked in sales my whole life. I've worked to hand sales. I used to sell luxury watches. So I used to be literally right in front of people all day long and pass them watches and get to watch their body language and how they speak. And it's funny. I noticed something that Karen does, and maybe you all will agree with me. But when she's recalling the event, she said, I watched him go to the side door. her eyes get very wide. And that to me, and again, I'm not a body language expert, just going off experience of talking to people. When people recall things, have you ever noticed that? Like their eyes get big, like they're almost remembering the scene or what they saw. Like, hey, you know, like I saw him walk up to that front door. You know, they're opening their eyes. They're trying to, you know, have you, I guess, like, what's the way I'm trying to explain this? Get a visual cue of what they saw. Watch Karen's eyes again. I always notice that in this video.
He goes up the driveway and approaches the side door. And as I see him approach the door, I look down at my phone.
Reed says after about 10 minutes of waiting in her car, she became irritated that O'Keefe still hadn't gotten in touch with her. And she drove back to his home where she continued calling him before, she says, she fell asleep around 1:30 in the morning. She then says she woke up before 5 a.m. He still wasn't home. She then started.
Oh, did I miss it? I missed it, didn't I? Let me go back here. I promise we'll get through this. All right.
I said, can we make sure we're welcome here? Nobody extended the invite to me. I didn't hear the invite extended to you.
They drive to the Alberts'
Watch
house.
your eyes here.
What happens next is disputed.
So I pull at the foot of the driveway. It's snowing. John has no coat on. It's windy.
Here.
So I drop him off. He goes up the driveway and approaches the side door. And as I see him approach the door, I look down at my phone.
Reed says after about 10 minutes of waiting in her car, she became irritated that O'Keefe still hadn't gotten in touch with her. And she drove back to his home where she continued calling him before, she says, she fell asleep around 1:30 in the morning. She then says she woke up before 5 a.m.
Denmark.
He still
Wow.
wasn't home.
Thank
She
you.
then started canvassing the neighborhood.
Just going to drive around in the 2 square miles that we spent the preceding night.
After 20 minutes of unsuccessful searching, she called John's friend, Carrie Roberts, and Jennifer McCabe, Brian Albert's sister-in-law, who was also at his house the night before. The 3 women together now headed to Albert's home.
How soon was it when you pulled in there that you saw John's body?
Immediately. And what struck me when I saw him was his mouth was open a little bit and his eyes were shut and he had spots of blood in different areas on his face.
O'Keefe was taken to the hospital and pronounced dead. He died from blunt force trauma and hypothermia. And it wasn't long before Reed became the #1 suspect. Authorities say they had noticed a cracked taillight after they seized her car.
I had told both Jen and Carrie that I cracked my taillight. I said, I just hit my car on top of everything, but I didn't look at the damage. And both women said, it's cracked. It's cracked. Calm down. You cracked your taillight.
Both women.
You're okay. Let's go look for John.
Yeah.
But according to
Crack
police
your
statements,
taillight.
Jennifer McCabe
Crack
told
your
authorities that
taillight.
while they were looking for O'Keefe, Reed stated, could I have hit him? Did I hit him? And when O'Keefe's body was discovered, first responders who arrived on the scene say they overheard Reed make other statements.
Firefighter said that you said, I hit him, I hit him, I hit him.
I said, I hit him. It was preceded by a did and proceeded by a question mark. What I thought could have happened was that did I incapacitate him unwittingly somehow, and then in his drunkenness passed out?
When you walked out of the bar, how many drinks had you had?
I had had probably about 4.
The Commonwealth says that you had 9 drinks that night. That's what the prosecution says.
I don't believe they're saying I wasn't in my right mind.
Well, they were saying you were intoxicated. Is it possible that you might have hit him unwittingly in your admittedly very large SUV?
No, not possible.
3 days after O'Keefe was found dead, investigators arrested Reed for manslaughter. She was eventually indicted on second-degree murder. Investigators reported they found fragments of broken glass on the rear bumper on Reed's vehicle, and that a broken cocktail glass was found by what appeared to be patches of blood near O'Keefe's body.
The victim, Mr. O'Keefe, is last observed on surveillance video with
Good,
a
Ben. That's
cocktail
great.
glass in his right hand.
Good. I'm glad you're all
Same
back.
arm that's injured, the same type of glass that is then recovered from the bumper of the defendant's car.
In court documents, the prosecution also claims that Reed's blood alcohol level could have been between 0.13 and 0.29%, above the legal limit of 0.08. In addition, they say pieces of Reed's tail light were found on the scene the day O'Keefe's body was discovered. More fragments of that tail light were found the following week, according to Canton police reports, after the snow melted, which revealed more at the scene. But Reed's attorney, Alan Jackson, has a different theory about how those fragments of taillight got there.
Those pieces of taillight were placed there after the fact.
You're saying evidence was planted.
Love it.
The pieces of taillight were
Love
planted
it.
after the fact.
What does the defense believe actually happened to John after Karen dropped him off?
I think he walked into the house. I think he was confronted, was likely brought down to the basement. I think that confrontation got physical and he was beaten. He was beaten to a point of unconsciousness.
Jackson argues that the autopsy photos of O'Keefe support his theory and not the prosecution's claim.
Looks like he's been in a fist fight and he's been beaten. He's got some defensive wound bruises on the backs of his hand. He's got this massive laceration on the back of his head, a big giant gash, about 2.5 inches, exactly lateral, going from left to right. 2 black eyes, cut over his right eye, cut over his nose. This was a cover-up that John was murdered inside that house. His body was placed outside.
But in a statement to ABC News, the prosecution says there was no conspiracy or cover-up. Such claims have been systematically refuted by evidence submitted to Norfolk Superior Court. The prosecution also said that, according to O'Keefe's cell phone GPS records and 11 witness statements, O'Keefe never entered Albert's home, and that a medical examiner found no signs of Mr. O'Keefe being involved in any type of physical altercation or fight.
There's no evidence that Mr. O'Keefe was beaten and left for dead. There was no evidence of any defensive wounds.
ABC News reached
gonna
out
hear
to
that
attorneys
tonight.
for Brian Albert and Jennifer McCabe, but did not hear back by the time of this broadcast. In a previous statement to the Boston Herald, McCabe's attorney said the whole scenario is baseless. Reed is scheduled to appear next in court again in September.
Okay. You know, it's funny. I saw some conversation about let's see. It's probably too far now. I'm trying to find a chat. Let's see. Let's see. Sorry, I'm just trying to find a chat. I got to go through a long chat thread. And it keeps bumping me down. So hang on. Bear with me for a second. Deal with me for a second. I'm just trying to find a chat. This conversation. Let's see. I wish you could just type the person's name in and then go back to that chat. I wanted to pull up a chat. Okay, so I just want to pull this up right here. Jerry says that Karen put her house on the market today. Okay, this is something that I've known about. And it was just supposed to be kind of kept hush hush. Obviously, it's going to get out there now. I just wish, please, just hear me out here, okay? Let's give Karen some privacy during this time. If you're not a serious buyer, please don't show up at the house if they have an open house. I don't know how they're doing it. I don't know if it's going to be a private showing, but please, 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 please give Karen her privacy. Okay. I don't want a whole bunch of people showing up at the house, creating a scene. That's not what this is about. Let's just give her her privacy right now. Please don't show up at the house. We don't want a mob over there. We don't want to have, Mansfield police go over there and get people out of the area. That's not what this is about. But please just don't drive by the property. Don't bother her. I'm pretty sure she's probably not even there, but let's give her some privacy during this time. Let's not keep driving by the house to see if we can find her or see her or anything like that. So let's just please do that. So that's kind of my public service announcement in all of this. Let's just give her some privacy during this time and let her, move on with what she needs to do. So, anyway, I digress on that. Let's get to the court hearing. I know it's going to be a long live tonight, but before I do that, I have a sponsor of the show that I actually want to pull up and play this commercial for you all. So let's do that first before we go to the court hearing. All right, here we go from our sponsor.
Ladies and gentlemen of the court, allow me to present the evidence on Kelly's Popcorn Shop.
This is a different case with regard to one specific issue.
The facts speak for themselves. Each kernel is meticulously popped to perfection, achieving a balance of crunch that is simply beyond a reasonable doubt.
If I allow this, and we really need to see how things develop.
There is no doubt that Kelly's Popcorn Shop is the best place to buy your popcorn. Our thorough reports have concluded that Kelly's Popcorn Shop should be the only shop you consider when purchasing popcorn.
I'm happy to have that additional conversation.
It is accused of bringing joy and satisfaction to every occasion, even courtroom breaks.
Why don't we take our luncheon break?
Mr. Jackson, an esteemed popcorn connoisseur, wholeheartedly recommends Kelly's Popcorn Shop.
I do.
When it comes to toppings, many have asked, can you tell me what topping to never put on popcorn?
Bukkake?
The jury will undoubtedly find that Kelly's Popcorn Shop offers the best flavors.
Well, it's one of the busiest in the United States.
The variety and delectable options available are unmatched. The verdict will be unanimous. A popcorn enthusiast can attest to the temptation of Kelly's popcorn. When asked, would you like to eat popcorn?
Yeah, it's pretty awesome.
A discerning consumer, when asked, would you buy popcorn from anyone else's shop?
So no, sir.
Furthermore, Kelly's Popcorn
no.
Shop is easy to find.
Well, I'd like you to direct me where to look.
And although Kelly may have friends selling popcorn too, none compare to the quality and taste of hers.
Of course, there are other friends, but
Miss Gianetti, please no more, of course.
Of course, Your Honor.
Kelly's Popcorn Shop reigns supreme. In conclusion, ladies and gentlemen, Kelly's Popcorn Shop is a cut above the rest. The evidence presented clearly demonstrates the unparalleled quality and satisfaction it offers. There is no doubt that this is the ultimate popcorn.
I love it.
We're done here.
Kelly checking in the chat. So listen, let's do this. Sorry, Paul, I had to do it. She has the Reed name. I love all of you. I actually supported all 3 campaigns this morning on my Facebook page, but she's got the Reed name. I got to go with Kelly. So anyway, if you can, and if you want, please, let's show some support to Kelly. She's got, 28,778. I'll drop the link in the chat. If you want to buy some popcorn to help Karen out with her defense fund, please do. It's all in good fun, and it does end tonight. So we would like to get some orders in for her. So and there's different variations that you can buy through the set of 3, the 4, and it levels all the way up as you go through. But please, so we had Kelly at 28,878, Paul Cristoforo at 8,000. Wow, Paul, good job, 8,800, and Nick Rocco at 5,141. And I don't want to take anything away from the other. Michaela is at 1,760 and Lorena at 866. So good stuff, all in good fun. I love it. And of course, like I said, anybody that donates tonight, we're going to kick back to helping Karen Reed. You know that I do that as well too. So either way, let's get some money together for Karen and help her through this fucking stupid bullshit nightmare that she's been stuck in for the last 2.5 years. We will keep fighting. All right, let's get to the motions hearing. Again, this is September 15th, 2023. We got a little ways here, so buckle up and let's sit back and go through this hearing. Thank you all for being here. I appreciate y'all. I'll boost the sound up a little bit. And it's the one that everybody cheers when Karen comes in, from what I remember. This is the right hearing. speed up a little. Oh no, she's already in the courtroom. I thought this was the one where they cheered. Let's see. So the audio is going to be a little tough at first for about the first 5 or 8 minutes, but it gets better.
All right. So today was originally it was just scheduled for status on the motion to come out.
This is just scheduling.
Motions.
Here we go. I was just ironing out scheduling. So they switched courtrooms because of I guess they didn't want as many people in the larger courtroom. They wanted to keep this down smaller, and it was easier to see the jury down in the smaller courtroom. That was the biggest complaint from the defense, because of the way that the jury would sit. They would not be able to see the witnesses' reactions, and that's very important. It was almost like they were sitting way behind the witnesses, and you can't see their facial expressions or their body expressions, and that is very important in this case. Super, super important. Judy, thank you so much for becoming a new member. We're going to add $5 to our total tonight, and we're trying to get to at least $100 for Karen. So 25% of all donations come in. We'll add that up at the end, and we'll kick that back to Karen Reed's Defense Fund. Okay, let's keep playing here.
Your Honor, if the court could define which of there's multiple motions, both from the side, the record holders from, or with related to Mr. Lally's motions, NBC, ABC, alarm.com. Is that what the court's talking about, or the?
Do you have any reason? Mr. Lally said that he sent out notice to all of the record holders pursuant to Rule 17.
Right.
And that he only heard back from one person. I know some of these motions were filed late, so my concern was that some of these record holders.
Yeah, the audio on this one is not good. See if I can find a better version of it.
Not completely. As it relates to the town clerk, no issue. As it relates to Google Nest and Google, we have no issue. As it relates to NBC and ABC, I have no issue with alarm.com, but the other two motions that the Commonwealth filed Rule 17B motions on, I do have an issue with, because I don't have enough information to be able to state with any authority that they have not received consumer notice. However, in speaking with both those entities, producers at both those entities, I have not spoken directly to legal counsel on either side, but for either agency. However, I was told by individuals who had spoken to legal counsel that they had not been served. They had not received any formal paperwork from the Commonwealth as yet. And that was probably, I want to say, 5 days ago, something like that, 5 or 6 days ago. So that's the latest information I have. In other words, I don't have information that they haven't gotten notice, but I certainly don't have information that they have gotten notice either.
I'm sorry, the audio is horrible, and I think they fix it a little later on. Oh, this is bad. Corey, thank you for becoming a new member. Appreciate that. Lee, thank you so much. $10 says, so many new people following the Karen Reed case. Pre-trial hearings are so important. In the lull, go back and watch. It's super, super important. Meg, thank you so much for becoming a new member. What So we'll add $5. The audio does get better. Yeah, I remember. They do fix this. Yep. Don't worry. It will get better. It just takes about 5 or 10 minutes till they finally realize that it's shit. And again, I just wanted to make the announcement on my show tonight and just make sure that people understand this. If you live in and around the local area where Karen Read lives, we do not want you going to her house that is up on the market for sale. Is a private showing only, and you have to be pre-qualified. So if you are interested in purchasing the house, you can go through the real estate agent or through Zillow. And I just wanted to make sure that people understand that. So don't show up over there and try to see if Karen is there or whatever. Let's make sure that she's safe. Just please use some discretion, use privacy right now. She needs privacy. I'm sure she's probably not even staying there. But anyway, let's continue here. The audio will get better, I promise. Nick. I'm going to speed this up. All right, here we go.
Sorry if it makes it uncomfortable.
Yeah, the audio's better. Perfect. And I have a little boosted too. Paul Cristoforo say, let's see if we can get Kelly to 30,000. Should be 30,000 by the end of this live. Yes. Please make your donations. Thanks for the 10, Paul. I appreciate that. All right, here we go.
I guess you'll have to take a seat. Why don't you just sit down? Thank you. I'm sorry, Mr. Henning. All right, Mr. Jackson, I'll hear you on your motion.
All right, Paul. I knew what you meant.
Very little question of the security camera footage capturing the interior and exterior of the Albert
Pibbles,
home.
thank you.
The scene of John O'Keefe's
Remember,
death
$5
is
added, please.
evidentiary. It's relevant. It's material to the defense, and it should be material to the prosecution, I would think. It should be
I
material.
have a proposed order from the Commonwealth, so I don't know that there is that much of an opposition to
There may
this.
not be, but there may be an opposition from, it sounds like Mr. Henning has some things to say as well, and so my comments are directed as much to that as it is to the Commonwealth. We've known for some time that there was a camera at the house of the Alberts, but what's truly interesting is how we know that there was a camera at the house of the Alberts on the date that John O'Keefe was killed. We know that there was a camera at the house, Your Honor, because a grand juror asked Brian Albert during the course of his testimony about the camera. It wasn't the Commonwealth that asked that question. The assistant district attorney went through 26 pages of questioning at the grand jury, a full panoply of questions surrounding the circumstances of John O'Keefe's death on January 29th, 2022, and not a single question was asked about security footage that did or did not exist at the time. A grand juror had to step in and ask that question. And that's interesting in and of itself.
This is important.
This is a longtime law enforcement officer, Brian Albert.
I'm actually going to interrupt you.
See?
Mr. Lally, is there any objection from the Commonwealth?
She's already cutting it off. He's already cutting it off. They're talking about knowing that a camera is at Brian Albert's house, and she's already cutting it off. None of this was allowed in. So these are very important hearings to listen to. And that's why I wanted to come back and do these. You can all see how much evidence discovery was left out or would not be allowed.
To the motion being allowed, no. The only objection, and that's why the Commonwealth filed a modified proposed order, because it's seeking records from Google.
Okay, so we'll talk about the proposed order. Before I hear you, because we have so much to do this morning, Mr. Jackson, I do want to hear whether Mr. Henning is objecting to this. Come to a microphone, please, on behalf of his client. It will save us some time if we direct it to the order if there's no
I
objection.
do understand. I don't think my comments are going to be very lengthy, but there are some things that I do want to put on the record on behalf of Ms. Reed.
Okay, I'm
as
going to
it
ask you to
pertains
have a seat. I'll hear if there's an objection, and then you can figure out what you need to say if there's no objection.
Good morning, Your Honor. Greg
Morning.
Henning on behalf of the homeowner. With the proposed order
Brian
that the
Albert's
Commonwealth
attorney.
submitted in mind, that language, Mr. Albert, the homeowner, has no objection to the rule set.
Thank you. All right, I'll hear you now, Mr. Jackson. I don't know if you heard that. Did you hear Mr. Henning?
I think I heard him say that there was no objection.
To the proposed order from the Commonwealth.
The proposed order, the problem with the proposed order of the Commonwealth is it indicates that they believe that the information information is appropriate prior to January 29th, which
Just pull this up real quick. Shannon says, I'm outraged. You should be. You should be. Look, they're already keeping key evidence. Bev is pushing key evidence out of this case. She doesn't want to hear it. Jackson starts to go into his dialogue, goes into his presentation. She already goes, oh, wait a minute. Mr. Lally, do you have an objection? She's almost helping him. You should be outraged. You should be outraged. Let's see. Lady Law, 12-month member. 1 year membership. Look at this. My favorite argument from Jackson. Love it. 1 member supporter. I love it. 1 year. 1 year. All right, here we go.
which is in and of itself ridiculous. The whole point is to get the camera footage from the 29th, from the early morning hours of the 29th. We don't have, again, this has become a sort of a theme with the Commonwealth. They indicated they wanted to change the proposed order and literally put in the proposed order that any camera footage that we would get would stop at midnight on the 28th. We have to have the footage from the 29th. And I question whether or not that was as the Commonwealth.
Did you see number 3 of their proposed order?
Proposed order is.
I read it as it's asking for a longer period of time than you requested. It's more expansive than what you requested, Mr. Jackson.
That's why I wanted to do this.
Activation or setup.
It's very important to go back and look and listen to all these hearings. And I'll keep doing these all the way up until the 22nd if you want me to do them. I'll play some of the most key, pivotal, important ones. And this one is very important. And you're going to hear about discovery and evidence that was held back from the defense. This case should have been dismissed. It should have never went to trial.
Information for any Google Nest camera registered to Brian Albert or Nicole Albert prior to January 29th.
Right, that's 1. Number 3. The Commonwealth's proposed order is more expansive than the defendant's proposed order. If there's an objection to that, I'll hear you.
But obviously, there's no objection to us expanding the time. We want it as expansive as possible.
I just want to make sure you have the motion. Do you only have
already
the first page of it?
No, I've got the motion. The motion was supplied to us, again, this is the second time this has happened, when I was on a flight yesterday.
Mr. Yannetti, did you receive this?
Yes, Your Honor. We both received it. I mean, I can read it on my phone as well as I can read it on a piece of paper. My issue is, as I indicated, I want to make sure that the proposed order extends to the early morning hours going through January 29th. As long as it does, then obviously we're on the same page and I have no issue with the Commonwealth's proposed order. I want to make sure that, and I don't have any issue with the Commonwealth's proposed order as it relates to other Google apps, for lack of a better phrase. The activity apps, financial apps, things of that nature. That's not what we're interested in. We're interested in Google Nest data. So as long as that proposed order includes and encompasses January 29th, then we have no objection, obviously.
Mr. Lally, am I reading this wrong?
No, Your Honor. Actually, number 1 that Mr. Jackson was taking issue with is actually directly copied from his own proposed order. Number 3 is, as the court noted, a more expansive time frame that goes up until 8 p.m. because if there were to be video footage, the Commonwealth would be seeking that to expand beyond the police response and everything else that's been taken issue with over the course of this case. So the only differences between the Commonwealth's proposed order and the defendant's proposed order is, number 1, excising any sort of other Google account information. Which
And I think Mr. Jackson just said he didn't have an objection to that. All right.
And expanding the time frame.
Okay.
The only wording that was changed under number 1 that we have an issue with is again, we believe it shouldn't be prior to, but inclusive of January 29th, any setup inclusive of January 29th, as well as the end of that same paragraph that indicates that the request is for information from any on-site activation by the residential user and not an activation that might occur at point of sale. There is no such thing as point of sale to our knowledge of a Google Nest activation system. In other words, the setup, I think that's a throwaway line, and I think it should be stricken from the order because it's confusing. There is no point of sale activation that we're aware of for Google Nest systems. But other than that, that's relatively pro forma. If sum and substance is that we get the Google Nest data, that's what we're concerned with.
All right. And you'd prefer that I add the expansive time frame than the
Correct.
less restrictive time frame
Correct.
that you requested?
Yes.
All right, so Mr. Clerk, you can mark this. I'm going to hold on to it because I'm going to take a look at the orders more closely, but Rule 17 is allowed, no objection.
Thank you,
from the
Jay Morgan.
homeowner. So
Appreciate that.
Thank you for
Thank
coming
you.
in for that, Mr. Henning.
Justin Evan from Taunton. Thank you. $5. Excuse me.
All right, so now we'll do the Commonwealth's, the motion for the alarm. Is there an objection to that, Mr. Jackson or Mr. Yannetti or Ms. Little?
Not from the defense, Your Honor.
Okay. So this is the Commonwealth's motion for records alarm 121. Did you propose an order with this, Mr. Lally or Ms. McLaughlin? Did you propose an order that maybe I don't have?
Should be an order attached. I can provide the copy with an additional.
You might have it, Jim.
Jim.
All right.
Jim.
Thank you. Thank you.
Jim. All right, let's double time this a little bit. Speed it up just a wee bit here.
All right, so Jim, I can give you back that full
Excuse me.
motion. All right, I'll hear the Commonwealth. Do you want to start with?
Irene,
I
thank you
have
for the $10 on Cash
First,
App.
the ABC News one. Why don't
Thank
I
you.
hear you on that?
Just, it makes no difference to myself, Your Honor, but there's also another related motion to that, Cameron.
Which is one, oh, to the camera one?
Yes, from the House indictment. It's a motion to compel to preserve and
I don't,
request for order production.
I don't believe I have that. When was that filed?
Same time as all of the others.
It could, I mean, I just have copies, so it could be that it was that. So Jim, it's probably somewhere around 121, maybe 123. Is there an objection to this from the defense?
No.
Thank you. Okay. All right, Jim. All right, so why don't I hear you? It doesn't matter to me whether it's ABC or NBC that you want to start with.
Your Honor, I think we can take them sort of in tandem. It's essentially the same issue, the same type of factual background. Essentially, what Commonwealth is requesting is any and all video footage, including raw or unused or unaired video footage of interviews, specifically with the defendant herself. She submitted herself to interviews with multiple news programs. The content of those interviews was sort of interwoven within a narrative story, which the Commonwealth would submit as a fair inference that there's additional footage that is available. In specific reference to the NBC, there's an indication from the broadcast that this is part of a larger program to air at a future date. These statements by the defendant, as the court is well aware, are entirely admissible. They were freely given by the defendant. In each of the respective news broadcasts, the defendant, at least in part, so some of the statements she's on her own along with a reporter, and some of the other statements she's seated at a table with counsel. So as it pertains to any of those statements, there's an exception to the hearsay rule as far as statements by a party opponent. Any statements that she makes to these outlets, she's free to make, but the Commonwealth is seeking production of those statements.
Okay, who am I going to hear from the defense?
Your Honor, at this point, we don't have an objection to Rule 17. I think I know there's going to be a speed.
Speak into the microphone.
Sorry. And that microphone's going to pick us up.
It will just be closer to it.
Sorry about that. We don't have a principled objection to Rule 17 because it's really not our dog in the fight, as it were. In terms of ABC and NBC, if the subpoena's issue, I have every reason to believe that both NBC and ABC's legal department will take great issue with the subpoena for rules for reasons of their own.
Oops, sorry
The
about
defense
that.
is not taking a position on the Rule 17.
Tina, thank you so much for the
It's
two.
not our fight.
Okay. All right, so do you want the opportunity to speak to legal counsel and see why they weren't represented here today, Mr. Jackson?
I would like that opportunity. It is unusual, I think, I suspect that there may have been, and I don't want to speak for the Commonwealth, they know better than we do. Both NBC and ABC are out of state. I don't know that they were served out of state.
Of course,
Right?
I think the Commonwealth, yes, they're
I'm
served,
not
it's
sure.
right in the pleadings. It's
But I'm
right in
not
the
sure
pleadings.
where they serve notice. I just don't know, because when I did check, both legal counsel, both offices, general counsel for NBC and ABC indicated to me through another person that works there that they had not gotten any information concerning this issue. So I would like an opportunity to check with legal counsel.
Okay, so
because
I will,
she does have an interest in it.
I will take the motion under advisement.
What happened?
If they want to be heard,
Someone on
I will
Zoom.
give
Look
you
at
1 week
Aiden.
for them to give notice to this court by way of letter of legal counsel as to why
Someone
they
on
did not
Zoom.
appear here today. And
Understood.
then we can see about setting up a hearing. And if your position is that you don't object to it and it's just with them, we'll set a date.
Thank you, Your Honor.
All right, so I'll do
Oh,
the,
real quick, I have some breaking news. Breaking news. Hang on here. In the Karen Reed, from the Karen Reed camp, I have breaking news. Hang on, everybody. Let me pull this up. Breaking news.
I finally decided to tell the world what I witnessed at the Kelly Reed Popcorn Camp. I've been involved at the camp from day one. Kelly's tactics are very sneaky. I will talk about the daily events at the camp headquarters. Please bear with me as this is hard to talk about. Here are some of the key players involved. First we have
Watch 11 Alive News at 11 p.m.
All right. So if you want to buy some popcorn, buy it from Kelly. I sent the link there. Please help her get to her goal tonight. And wow, we're at 29,296. It'd be great to get at 30,000 by the end of this stream. So all in good fun. All right, let's go back to the hearing. I think I had everybody on their toes there for a second. All right, here we
say
go.
both of those motions. All right, why don't we do the motion to compel and then we'll get into the exhaustive testing motion. Is there an objection to the exhaustive testing motion?
At this point, Your Honor, there is.
Okay, so we'll
there's
hear the
some technical
motion.
reasons, but
We'll do the motion to compel first.
thank you.
And so when this motion was first filed, and I do appreciate, Ms. Little, that you did get it to me in a timely manner after the last hearing. I do appreciate that. And I appreciate the detail of it. So then we have the Commonwealth's response that then maybe limits some of what you have there. And then I've got your response to the Commonwealth's opposition. So I think
where
that's
Eliza
where
really
we have
shines
you
here.
focused.
Great.
But has that changed at all since you filed this? I received additional statements of compliance by the Commonwealth.
I will address those today, Your Honor. There's 5 sort of outstanding categories of evidence that we still have not received. I did receive a packet of information today, but I'll go through that for the court.
Okay, go ahead. So let's do what you address in your reply.
Thank you, Your Honor. It has now been a year and a half since Ms. Reed was arraigned in Norfolk Superior Court. A year and a half, and the defense still has not been allowed to so much as look at the physical evidence that the Commonwealth has had in its possession for 21 months and has so desperately withheld from the defense out of fear of what it might show. That is unacceptable, that is unconstitutional, and that clearly violates the mandatory discovery provisions set forth in Rule 14. As I informed the court, there are 5 categories of mandatory discovery that continue to be withheld by the Commonwealth, and I'd like to go through those in turn. There are first 56 items of physical evidence that we have been unable to view, unable to independently test.
Are these the items that are at the lab for testing still?
That's correct, Your Honor.
Thank
It
you, Dina.
includes all of the taillight pieces, all of Mr. O'Keefe's clothing, and all samples taken from Mr. O'Keefe's clothing and person. This is the seminal evidence in this case. Your Honor, this is not a complex legal issue. The United States Constitution, the Massachusetts Declaration of Rights, and Rule 14 all require that Ms. Reed be permitted to inspect and independently test this evidence. Rule 14 could not be more clear. Quote, the prosecution shall disclose to the defense and permit the defense to discover, inspect, and copy material and relevant tangible objects at or prior to the pretrial conference. Our first pretrial conference was on August 12th, 2022. The compliance date for mandatory defense access to this physical evidence was more than a year ago. In opposing this motion, as Your Honor noted, The Commonwealth has tried to excuse its blatant discovery violations by claiming lab protocols and procedures simply won't allow us to access this evidence. But lab protocols and procedures are of no legal moment, Your Honor. They don't trump the law. In fact, Rule 14 actually contemplated that this might be an excuse that the Commonwealth gave. It specifically says it doesn't matter if the physical evidence is not in the physical, actual, tangible possession of the Commonwealth. If that evidence is in the possession of any agency who participated in investigating and evaluating the case and reports to the prosecutor, which clearly the Massachusetts State Police Lab does, then discovery is mandatory. That's Rule 14. As this court well knows, this is not the first time we've requested access to the physical evidence in this case. So when Mr. Lally stands up, as I believe he probably will, and says, we're almost done testing, the defense can have access to this in 30 days, I want to remind this court that we've been here before. In fact, we argued this exact same issue before the court 6 months ago. And I think it's important for the court to be reminded of the representations that were made by Mr. Lally at that hearing. On February 8th of this year, Mr. Lally stood here in open court and made these promises. Quote, I did speak with the lab earlier this week, as well as last week, a couple of weeks ago, and on several different occasions. But my expectation, from what I'm told, is that their analysis and report should be complete within the next 30 to 60 days. Those were Mr. Lally's words in February. And my guess is that's what he's going to say today. But what is disturbing about those representations is that the crime lab actually keeps track of their communications with Mr. Lally. And when you review the crime lab conversation log, which was produced to us in Discovery about a month ago, this is what you see. Quote, note to file, date January 3rd, 2023. Entry by John Buello, person contacted, ADA Lally. Note, quote, emailed Commonwealth prosecutor on 11/21/2022 about the status of testing. No response back. Therefore, the trace items will not be tested at this time. If for any reason testing is needed, the items can be resubmitted to the lab for potential analysis. Trace assignment closed, no report. And what you also see is that between January 3rd, 2023, which is the date of that entry, and the date the Massachusetts State Police Lab apparently closed this case, and February 8th, which is the date that Mr. Lally stood here in court and made those representations that he was so desperately trying to expedite testing, there is not a single record of communication between Mr. Lally and the lab that's contained in that conversation log. That's not Mr. Lally's hands being tied by lab protocols and lab procedures. In fact, the assignment was closed because he failed to answer his emails. That is deception, Your Honor. So when the Commonwealth stands up and says that the defense can have access to the physical evidence in 30 or 60 days, that's not good enough. We need court intervention. We need this court to order the Commonwealth immediately provide us access to these critical items of evidence and set a date for compliance, because that's what the law requires. That brings me to the second category of evidence that we're missing. Your Honor, for quite some time, we've been asking for access to the Lexis infotainment system and the Lexis telematics system. As of this morning, our expert was able to get in touch with Trooper Dorino, and they're currently working on coordinating a time to hopefully analyze that evidence. I'm hopeful that the Commonwealth will be forthcoming and allow us to obtain our own analysis. If there are any issues, we will plan to file a proposed protocol for the examination of that evidence with the court.
I want y'all to, and I'm sorry to pause Liz because she's just has this great presentation, but I want you all to understand this is in violation of Karen Reed's rights right now. What's happening in this hearing? This trial should have been dismissed. It should have never went to trial at all. They are violating Karen Reed's rights. It's crazy. It's absolutely crazy. And you can see the fix was in. The fix was in.
Court, but I'm hopeful it won't come back. The third category of evidence is the handwritten notes of law enforcement. As this court is aware, it was filed with our papers. Law enforcement was ordered to preserve all handwritten notes.
Cindy, thank you for
taken
the
in connection with this case.
$20 on
That was done in Statler
Venmo.
District Court on February 2nd.
Appreciate
2022.
that.
And I know Your Honor sort of reaffirmed that
Very
order
close
just in
getting
passing
to
during one of the court appearances when we
$50
asked
for
her to
Karen.
renew it.
Thank you.
We know law enforcement took copious notes in this case because most, if not all, of the reports were drafted weeks, even months after the actual interviews or investigation took place. We're asking for the court to immediately set a compliance date for production of those notes. If the Commonwealth has nothing to produce, then we also need confirmation of that because it's in violation of a court order. The fourth category are reports, handwritten notes, and mapping documenting the recovery of evidence from the Albert residence. This information should have been produced over a year ago. If you were to review all of the police reports in this case, as we've done, then you might mistakenly believe that there were only 2 searches of the lawn of 34 Fairview Road that resulted in the recovery of taillight pieces. Those searches were on January 29th at 5:45 p.m. by the CERT team, and there was a second search on February 3rd, 2022. But those reports are not complete because according to photographs of the evidence bags in this case, which we just received on July 25th, Trooper Proctor claims to have actually recovered taillight pieces over the course of 5 additional undocumented searches of the Albert residence throughout the month of February. The only reason we even know about these searches is because when Trooper Proctor logged these pieces into evidence, he had to write his name, the date, and the place those pieces of taillight were supposedly found, 34 Fairview. That's 5 undocumented searches, Your Honor. We don't have a police report for any of those. No notes, no reports, no photographs of where those taillight pieces were found in the
You're
yard.
welcome, Miss.
No memorialization of individuals who called Trooper
It's
Proctor.
important. This hearing is very important.
That is not acceptable. If this information exists, we're entitled to it. We need a short compliance date for the production of these notes and reports so that we can at least attempt to prevent.
I mean, Liza's actually like laughing. How, you can hear it in her voice. She keeps ending some of her sentences with a little bit of a laugh because it's so preposterous what's gone on here. This is a straight violation of Karen Reed's rights. This should have been dismissed immediately. If this judge wasn't a fucking jellyfish and actually had a spine, but we know that the fix is in, if she actually had a spine like the judge in the Alec Baldwin case, she would have dismissed this. She would have made the Commonwealth answer for this and then dismiss it, just like in Alec Baldwin's case. The prosecution get up and stand, defense cross-examining. See you later. Have a good one. Dismissed. Ren, thank you so much. Bev is so dismissive and condescending. It's infuriating. Thank you for all that you do and keep doing to help Karen and the community, invested and motivated until the next appearance. Absolutely. That's what we're here for. That's exactly, just keep this going in the news cycle. It's very, very important. Keep it going. Keep talking to your friends. Keep talking to your neighbors. Introduce people. Bring them to the channels that talk about this case. Show them who's doing it. Turtle Boy, me, Glare, whoever. Get the word out there. It's important that people start hearing about this case if they haven't, and watching these hearings.
Further fabrication of evidence. The 5th category of evidence, Your Honor, is the raw data associated with the CERT team search on January 29th at 5:45 p.m. We received a disc this morning from Mr. Lally. I obviously have not had a chance to review that yet, so I don't know what's actually contained on it. This has become somewhat of a pattern in this case. So I'm hopeful that everything's on there, but I'm not able to guarantee that for the court. He also indicated that there are additional materials that are forthcoming. Obviously, we haven't received those yet. I'm asking the court to set the compliance date to make sure that we actually get the information that we've requested.
Okay, thank you. Mr. Lally?
She dismissed it. Look at it.
Your Honor, I'm not quite done.
Oh, you said there were 5.
Look at her face. Look at Liza's face. She's like, you gotta be kidding me. Let's back that up a little bit. And I'm going to play it in real time. Watch her.
Indicated that there are additional materials that
like,
are forthcoming.
What?
Obviously, we haven't received those yet. I'm asking the court to set the compliance date to make sure that we actually get the information that we've requested.
Okay, thank you. Mr. Lally?
She's like, what?
Your Honor, I'm not quite
Yeah.
done.
Oh, you said there were 5.
Yeah, she's not
I was going to
done.
have a conclusion if I
Okay.
finish addressing the court.
Yeah, right. Let her finish addressing the court. We know that you don't want to hear it, Judge Bev. We know that you're in the fix with the Commonwealth. We understand that. I mean, it's been pretty clear here what you're doing. You've shut this defense out since day one. We know your agenda. Let her speak. Let her get to her conclusion. Let's get this on the record. We know that you don't want it on the record, but let's get it on the record. Okay, Bev?
Your Honor, we are entitled to this discovery and we need compliance deadlines.
I'm glad she fired back
Ms.
at her,
Reed has
too.
a
I'm not
constitutional
done.
right to a speedy trial and to prepare and present her defense. The law is clear that Ms. Reed was supposed to have access to all of the requested information in August of last year. Respectfully, Your Honor, we're asking you to please enforce these rules and get Ms. Reed the discovery that she's
Yeah,
entitled to.
exactly.
Thank you.
Thank you.
You want a fair trial? Let's get the discovery. Let me just do this. Jenna, thank you so much. Big chat. $50. $50 says, love what you're doing and what you do. Love the pre-trial replays. Great. Well, we'll continue doing them. We will continue doing them. Thanks for being here. All right, let's go.
Yeah, sure. Most of what I believe was just addressed was dealt with in the Commonwealth's response.
Sure, he's speaking in a microphone right in front of him, but if you can't hear him, can you go over to the podium, please?
I love how I love it. They make him move. Yeah, look at him.
So, Your Honor, I believe most of this.
I'm in so fucking deep. See him? See his body language when he went up to the. He knows he's such in deep water here. Watch him go. He goes. This guy sucks.
Almost a response.
Yeah. Yeah, go to the podium,
Sure,
dude.
he's speaking in a microphone right in front of him, but if you can't hear him,
Yeah, he
can you go
looks
over to the
back. Yeah,
podium,
Kelly.
please?
Watch his body language. Look at him. He eyeballed her too. Look at him.
So, Your Honor, I believe most of this
guy is fucking no spine.
I've
either.
addressed in the Commonwealth's response, and just to be clear, it's not an opposition to the defendant's motion.
Look at
The
Aiden
Commonwealth is well
laughing.
aware of its discovery obligations under Rule
Love
14
it.
does not oppose the defendant
Aiden
having
laughing.
access to these items. It's merely an issue of timing. Now, as it pertains to the first enumerated item, and there's been various modifications of this, and what I would say is that the Commonwealth is very aware of its ongoing obligations under Rule 14A1A, under Rule 14A4, as it pertains to mandatory reciprocal discovery and exculpatory evidence, and has provided counsel for the defendant with we're close to 300 items of discovery at this point. So this is not a situation in which the Commonwealth is I would submit, withholding evidence or preventing the defendant from doing any receiving any discovery. As soon as the Commonwealth receives it, it's provided to counsel. There was somewhat of an issue at some points over the history of this case where I have been providing discovery to Mr. Yannetti that apparently wasn't making its way to either Ms. Little or Mr. Jackson. My remedy for that has been to provide whatever I can, especially documentary evidence and attachments, email, so that it goes to all counsel and all counsel have access to it, which caused some of the delay as far as the testing in the lab is concerned in the first place. The lab was prepared to conduct its initial DNA testing back in May, had to wait until July, and then there was a second subsequent exhaustive testing, which wasn't conducted until August 1st because of the timing in which we received the exhaustive authorization form from counsel. What I can say is Ms. Little and Mr. Jackson were very good as soon as they were made aware of the issue, they executed the forms. I received them, forwarded them to the lab the same day. But unfortunately, all of the DNA testing was not able to be completed on that July day because of how late we received that particular assignment. As far as the items that are contained at the lab, again, these are the lab's policies. They're not my policies. There's nothing as far as anything that the district attorney's office and myself has done, any suggestion that we're desperately withholding evidence from the defense as we're afraid of what it might show is just patently ridiculous. The items that are at the lab there's no objection to counsel swabbing anything from any of those samples, inspecting them, photographing them, doing whatever they would like with them. The issue is when the lab is done. And as I detailed in the motion, was a recent trace assignment that was completed, not recent, but several months ago, actually. And it had to do with item 3-1 and several other items pertaining to the taillight. And so 3-1 is the passenger side rear taillight of the defendant's SUV. Items 7-5, 6, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 19 were all pieces that were recovered from the area where Mr. O'Keefe's body was discovered in front of 34 Fairview Road. Now, each of those were subject to a comparison analysis in which they were essentially fitted back together with item 3-1, which was the actual units from the defendant's SUV.
Thank you for becoming a new member.
That was believed to be done.
$5.
So the lab at that point had made a forensic link and was believed to have been done with testing related to that. Subsequent to that, there was a subsequent discovery based on some additional testing in relation to item 7-18.18. And that essentially was microscopic pieces. And when I say microscopic, they measure approximately probably less than 1/16 of an inch of clear and red plastic.
Rogue, did you get the $50 I called out? I called out 50. I think it's a little bit more than 137. I did have a $50 Cash App come in.
The pieces that were recovered from the victim, Mr. O'Keefe's clothing, specifically his shirt. Based on that discovery or analysis, there was then a subsequent trace assignment that was created in relation to comparative testing for those microscopic pieces to item 3-1, again, an item that the lab had theretofore thought that they had completed with. There's also an ongoing trace assignment for comparative purposes to some glass that was recovered from the rear bumper of the defendant's vehicle, comparing it to pieces of what they describe in the lab notes as cocktail glass that's found on the ground near Mr. O'Keefe and near Mr. O'Keefe's shoe. Of note, what I would say is that Mr. O'Keefe is observed leaving the waterfall bar last time that he's on video, carrying a short cocktail glass in his right hand as he's leaving from that facility. So that
Ron, thank you for the 5 gifted.
The DNA
Welcome,
results from
members.
July testing has been completed and provided to counsel. The DNA testing results from the August 1st testing,
25.
my understanding,
We'll add
should be
that.
completed. And again, these are not promises that I make. These are estimations based on what the lab can tell me as far as their expectation of
Such a
when
liar.
items will be completed. But the DNA testing I anticipate should be completed on or around September 26th. Those 2 trace assignments should be completed sometime in the last week of October. And there is additional DNA testing that has just been scheduled to be undergone shortly. As far as whatever the court deems appropriate to impose, obviously the Commonwealth will comply with that. We'll make arrangements with the lab. They do not allow outside personnel into the lab, so it would be a situation where obviously items that are currently undergoing testing are not going to be taken back from the lab. But if there are any items that have no forensic value left to the lab, once this sort of round of testing is completed, we will certainly pick those items up and make them available for counsel. But
Do you anticipate that this will be the last round of testing for DNA?
I anticipate it will, but at the same time, it depends on what the other testing shows. So it's typically what the lab is going to do is they're going to test until they get a forensic link, or either they do or they don't. But basically, so without knowing what the results of the testing that's just undergone, is just about to be undergone, or is undergoing currently, I can't speak as to what those results would be, and therefore I can't speak to whether or not there would be any need for additional testing.
Okay.
As it relates to the Lexus infotainment and telematics, I'm just a little confused because initially how it's phrased in the motion to compel is it's sort of incorporating all kinds of different material. So it's talking about an ACM, EDR, LSS. Now the ACM is the airbag control module in the car. EDR is the event data recorder. LSS is the Lexus safety system that's specific to a Lexus. All of those items are in the vehicle. And I've endeavored to arrange, should counsel have an expert that wishes to view or download that material directly from the vehicle themselves, all of that material, including the raw data, has already been provided to counsel. Way back in May of 2022, Mr. Yannetti had retained a reconstruction expert who had actually gone to the vehicle and downloaded the ACM material. So I'm just, what I was told most recently is that they don't need to look at the car, or they don't want to meet with Trooper Paul from the CARS unit to do anything with the car. As far as it pertains to the Burla and the telematics, as I've stated previously to Your Honor in court, the issue is, and just for the court's understanding, the Burla is, think of the Burla as a Cellebrite for an infotainment system. So it's essentially the software that downloads it. The issue is that Burla, which is essentially really at least the only certified forensic tool that I'm aware of that pertains to those types of systems, they receive updates periodically from the manufacturer. I believe there's another one coming up in a month or so. But I have no information. We reached out to Burla numerous times, but I don't have any information as to whether or not this make and model of a Lexus is going to be part of that update that they provide. But up until we receive an update that can actually read and parse the data that's contained therein, it's an issue as far as, you know, there has been data that we've extracted and we provided to counsel, but it's essentially unreadable data at this point. I am aware that Trooper Garino from our office spoke with counsel's expert yesterday, actually, in regard to seeing what can be done, what had been discussed, and what I had discussed and discussed in the Commonwealth's response is what's called a chip-off. Now, a chip-off is something that doesn't just pertain to the Burla or to the infotainment system. It also would apply to an event data recorder. It's the issue with chip-off is that it can be and likely would be destructive. So essentially what it involves is sort of burning the chip off of the unit. And in that process, sort of inherently within that, can be destructive to whatever data or material is in there. And you don't know that until you've already completed the process and started to look at it. And that is the reason that the Commonwealth has not endeavored to do that at this point and has opted to wait and see sort of if we can get an update from Burla or from the manufacturer to Burla so that we can read and parse the data. If that is something that council is interested in doing, again, I spoke to Ms. Little a little bit about this, that the Commonwealth certainly is not going to conduct any of that testing without them having an expert present to do any sort of chip off or any kind of destructive testing whatsoever. But if that is something that council is interested in, I would encourage council to file a motion with the court, as would be done with any sort of destructive testing. And if that's something that the court orders us to do, obviously we will be present, and council will have an opportunity to be present with an expert as well. The third category, I believe Ms. Little was referring to notes of law enforcement. Absolutely no issue with that. It's been requested I should have those in a short frame. If the court wants to order their production within, say, 2 weeks, that's absolutely fine. Reports, notes, and mapping from the CERT team. Again, these are items. What Ms. Little was referring to today is a GPX file that I just received yesterday from the CERT team, and that's why I'm providing it today. Obviously, sending it in the mail wouldn't do as good as handing it to Ms. Little today. But essentially, what I put on that disk is a GPX file, and it's a file that contains data that can only be opened in a mapping software. So in addition to the GPX file, I also put some mapping software onto the disk to make it readable. If council wishes to use a separate software application, obviously they're free to do so.
All right, let's take a quick break from Lally really quick. KLM, $5. I got to watch this. Trial 4 on Netflix. Innocent man framed for Boston cop murder. Eye-opening to the corruption out of Norfolk Superior Court and the police cover-up. And I can guarantee you there will be a great Karen Reed story, documentary. I can guarantee you that. I mean, we've all seen the crew out there. And there will be a documentary series. All right, let's buckle up here. Here we go. Thanks for the $5.
Do you expect to be able to do all that?
So that was provided today. The other part, as far as notes from the CERT team, there are no notes from the CERT team. I spoke to Lieutenant O'Hara from that unit. There are no notes. They have reports, they have diagrams, they have the mapping raw data. The only thing that I'm currently waiting on, should have in the next few days or so, is in relation to I don't even know if they asked for it, but it's something that I was looking for as far as dispatch logs and ALV data, as far as when they were dispatched and when they arrived at 34 Fairview Road, all of which should be logged, similar to items that's been previously provided in regard to the Norfolk County detective units. As it pertains to Trooper Proctor, 5 undocumented searches of the residence, I don't believe that those occurred. I will certainly look into that. And if there is any documentation related to those, whether they be notes, whether they be photographs, whether they be reports, again, the Commonwealth has no issue providing those in short order. That's something that I've heard the first time today while I was sitting here in court. Now, I believe the fifth thing pertains to the raw data, which again, the Commonwealth provided. So as it pertains to this or any discovery, there's been a number of other discovery items that Ms. Little and I have had conversations in regard to over the last several months, over the last however long it's been. But I would submit that when I'm asked of things, asked for discovery, formally, informally, whether by formal motion or not, the Commonwealth has no issue with continuing to abide by its duties and obligations under Rule 14. Whatever discovery I have or whatever discovery that I can provide, I'm happy to do so. That is.
Okay, Ms. Little, any follow-up with that?
Mr. Lally just listed a lot of lab work that has been done in terms of DNA testing. I just want to clarify for the court. I did review his opposition. There are only 2 items that are still subject to comparative testing. So we're asking that the rest of the items of evidence be made available to us immediately.
Yeah,
There's
thank
no
you.
reason to continue to withhold
Thank
those
you.
from the defense. As to the Lexus infotainment system and the telematics system and the EDR, as Your Honor can imagine, it's quite expensive to fly an expert from out of state to go look and interpret this data. We're trying to avoid having to do multiple trips of that. So while I understand the airbag control module and the EDR, which we already do have the data from them, are generally available, we're not going to have our expert fly out to do that until she can actually look at the stuff that's of substance, which is the infotainment and telematics system. As far as that's concerned, I know Mr. Lally has made representations to this court that the infotainment and telematics system have no recoverable data and have been hooked up to Burla. But Burla is just that. It's like Celebrate. There are hundreds of other softwares out there that are able to read and parse this data. Our expert is aware of what those programs are. She would like to be able to analyze the data. She believes that there's likely ways to do it that are non-destructive. She has reached out to Trooper Garino to inform him of this. He seems to be receptive to doing that.
Okay.
She won't know until she actually looks at it what particular softwares will be appropriate. We haven't been able to get that information from the Commonwealth because the actual photographs and things she needs to look at to see how to analyze the data we still have not received from the Commonwealth.
So you say that your expert is talking to the Commonwealth's expert today or yesterday?
Yes, I believe actually this morning is when I
Okay,
received
so after they talk, if you put in writing to me a protocol that you say your expert says there's hundreds of other methods of being able to read this data, put something in writing. It sounds like the two experts should be able to work it out, but if not, we'll deal with that. But I do want to know about that.
That's my hope. Thank you, Your Honor. With regard to the 5 undocumented searches,
Rogue Townie,
we
thank you
don't
so
have
much for
reports
$10
on those. Like I
on
said, we have
Cash App.
photographs of the evidence
Appreciate
bag
that.
that shows that taillight pieces were
Lily,
not put
thanks
into
for the
evidence
$1.99.
until late February. There were 5 undocumented searches.
Thank you.
They came from somewhere. So we need reports on this. And with that, I will submit, Your Honor.
Mr. Lally, earlier when you talked about the DNA, you said that on 9/26, one item,
Yeah,
the testing
DA.
should be complete, the other, the last week in October, and then you said the third, you were looking for a date, but I think you said soon. Do you know when whatever the third part is that you were talking about?
So to be clear, the 926A was in reference to the DNA work that was completed on August 1st.
Yes.
That was the second round of exhaustive testing in which their expert, Mr. Latham, was present. Then we had to delay because of first his availability and second not having the exhaustive testing form completed. The second that I was referring to in late October is in regard to 2 separate trace comparison analysis. That's sort of the estimated time of those reports completion. And then there is a subsequent 8 items that have been selected by the lab. And just to be clear, these are items that are selected by the lab, not by our office, for DNA testing. That has just, they don't require exhaustive testing. So that has just begun to be, I think it's scheduled within the next week or two to undergo that testing. And then just my own sort of estimate as far as typical turnaround time for DNA, in which, it has been communicated to the lab on numerous occasions. Every single
Excuse me.
bit of testing that's been done, as per the court's suggestion and direction, I've requested expedited analysis with regard to each of those. So that I would expect probably around the same time frame, late October, early November, as the trace comparison.
All right, so what I'm going to do is I'm going to order expedited testing on those 8 items that have not yet been testing. And
Lee chiming in $10. Thank you. Says Lexus uses same satellite emergency services as Murdoch's GMC. It's through OnStar. The data is there. Get the OnStar telematics. It's in the cloud. Murdoch was given it the last week of trial. Great point. Oh, excuse me. Do we hit 1K likes? We're at 866. Come on. We got 1,500 people in here. Let's smash the like button. Let's do that. It's free. Okay. And that helps get this stream out to more people. The more interactive you had on the video and this live today, we can get more people in here and actually start learning the truth. Learning the tooth. Thank you, Lee. Appreciate that. Lala coming in. I see another $10. $10. Thank you so much for all that you've done. I'm here with my 4-year-old grandson who just drew out a $5 bill for me to send to Karen for her defense fund. Wow, that's really sweet. Thank you so much. We appreciate that. Thank you. Thank you, thank you, thank you. Jet, wow, big super chat. Thank you so much. $50. $50 super chat. Thank you, Jet. I appreciate that. 25% of your donation tonight will get kicked back to Karen Reed's defense fund. We're so close to getting to that $100. I think we actually might be there. So at least we can give Karen $100. All right, let's go.
I want the Commonwealth to be able to report back in the beginning of November the results of all of the testing that's been completed. And if it's not completed, why and when you expect it to be completed. Why don't we have all of that by November 3rd? For B, the defendant's request number 4, for the infotainment, I do want the 2 experts to talk. I need more information on this. If it's something that there is other software that can read this, then we can move quickly with it. So I need to get that from you, Ms. Little. You need to talk to the Commonwealth. Your experts need to talk, and you need to put something in writing for me on that. Stand up at the microphone so I can hear you.
Can we have a compliance date for discovery from the Commonwealth so we can get the reports and the photographs we've been asking for so that our expert can make that analysis? She needs to know exactly what's in the car and have pictures of the circuitry.
Your Honor, if I could just speak to that. So the photos are on a disc and in the papers that I handed to Ms. Little this morning. Also, when I spoke to Trooper Garino, he indicated that following his conversation with Ms. Gaffney, who was the defendant's expert, yesterday afternoon, that he had forwarded an email with each of those photographs to Ms. Gaffney directly.
Okay, so if you talk to her today, if she still needs them, put them in writing and we'll order them to be produced. All right, so the request D, is the Office of Medical Examiner, is that all taken care of? The original death certificate? You didn't raise that this morning, Ms. Little?
Yes, Your Honor.
Okay, so request number 5 is all set?
Yes, Your Honor.
Okay, so regarding the request for all of those notes, a 2-week date. So let's get that by the 29th of September. I'll give you the same time frame to see about whether there are any photographs, handwritten notes, mapping
Coco,
documenting
thank you.
the recovery, the 5 undocumented searches
you
that
so
are
much.
outlined
I
in
appreciate
E
that.
of the defendant's response, reply to the Commonwealth's response. So 2-week date for that, 2 Commonwealth 929.
Excuse me.
The Commonwealth says that there is no raw data with the CERT team or no notes. Why don't you just tie up all loose ends and put that in writing, Mr. Lally, by 929?
Yes, Your Honor.
Thank you, Your Honor.
Okay. That was the whole purpose of today's hearing, was to be able to do that. So at least we've got that done. Now we move on to the Commonwealth's motion for an order regarding expedited testing. And the Commonwealth has asked me, I believe, to impound the results here, Mr. Lally?
As far as the attachments to the motion, yes.
Yes, okay. Is there any objection to that from the defense?
Let me just a moment, Your Honor.
Your Honor, I'm sorry. Did you say expedited testing or were you referring to exhaustive testing? Is that what you're asking?
Exhaustive testing, the Commonwealth's
Okay.
motion.
I'll let you address that.
So, okay.
Your Honor, there is an
Finally,
objection.
we can hear
Okay,
from.
so let me hear the Commonwealth end of the
Fine.
motion, then I'll hear your
That's fine.
objections. My question was simply on the impounding of the attachments. There's an objection to the impounding of the attachments? Okay, that was that question. I'll let you be heard on the motion, Mr. Jackson, but I'll hear from the Commonwealth first. And Mr. Clerk, the results that are attached here, Commonwealth satisfied me that they qualify for impoundment, and I will impound them. Yes, I'll put that in here. All right. So Lally, I'll hear you on the exhaustive testing motion.
Yes, Your Honor. So very simply put, there is 2 items that, as I just referenced earlier, have been subject to DNA testing in July of this year. Among those items was the root end of a hair, item 3-6.1 from item 3-6, which was a hair that was recovered from the rear bumper of the defendant's vehicle. The testing that the Commonwealth is requesting would surely be exhaustive based on the size of the sample. The MSPCL, the State Police Lab, does not have the ability to conduct mitochondrial DNA testing or the testing that the Commonwealth is requesting be done in this case. We've identified an external vendor. This item was initially marked by the State Police Lab for an external vendor because of that reason, because of the size of essentially what is the shaft ends of the hair. For those reasons, the Commonwealth is requesting that it be permitted to send it to Bodie Technologies in Borton, Virginia, which is a lab that the Commonwealth and Defense routinely use. I don't think there's any question as to the ability of the lab to do said testing. I've also attached as Exhibit C, reached out to Bodie just because obviously, whereas it would be exhaustive testing, we were curious, or I was curious as to whatever their policy was regarding observation of testing procedures. They do somewhat allow for it, but it's more sort of behind glass. And
It was helpful to me to be able to read it.
so for those reasons, whatever, I mean, that is something I think that is up to the defendant through her counsel as far as how she wishes to exercise that. And I'm sure whatever the choice is can be arranged with the lab. But whereas the testing is exhaustive and would be sent to an external vendor, I felt that a court order was appropriate in order to, prior to sending that sample off and conducting that testing.
So you are not asking that I impound Exhibit C?
It certainly doesn't have to be. I just did it as A, B, and
No,
C.
the only thing that requires is A and B. So I'm only impounding A and B.
That's fine.
All right. All right. Now I'll hear you, Mr. Jackson, on your opposition.
Thank you, Your Honor. As it pertains to the hair, the history of that hair is somewhat tortured. The Commonwealth has been trading on the argument in front of this court and in arguments, both oral arguments and motions that they've propounded or filed, that this item that was found on the back bumper on 3-6, which is 3-6.1, is in fact a human hair. they've gone so far as to suggest the relevance of that item is it's not just a human hair, it's John O'Keefe's hair, which would establish some sort of physical evidence that my client is, it inculpates my client. Except when we demanded that the hair be tested under the watchful eye of one of our own experts, which we had not had the advantage of doing at any time prior, it turns out that it wasn't human hair. On August 25th, 2023, there was DNA testing done on 3-6.1, and the analysis resulted in, quote, no human DNA detected. STR analysis not performed. I'm holding the DNA results. So after a year and a half, some 19 months or so of saying this was a human hair on the back of that bumper, turns out it's not a hair. And DNA testing indicated it was not a hair. And now the Commonwealth seems to be in some sort of triage mode to try to figure out how they made a mistake. And the mistake is, actually, I question whether or not it was a mistake, because you can make a mistake once. I don't know that you can do it 4 separate times. In 4 different filings before this court, 4 separate times after August 25th, after they had this document in their hand, which the highlighted portion says, no human DNA detected. They filed motions with the following phraseology, quote, the hair has been forensically confirmed to be a human hair, end quote. Not once, not twice, 4 separate times. And the last time was just this past week when they filed something in front of the Court of Appeal with that exact same phrase. The hair has been forensically confirmed to be a human hair. Your Honor, at some point, that's not a mistake. That's a deception. That's a knowing fabrication. That's a lie. And I don't use that word lightly. I'd love to consider this conduct feckless and irresponsible, but it's not. To do this 4 times, this is pernicious and it's intentional. So when the Commonwealth comes to us at the 11th hour and says, oh my goodness, hang on a second, let's all take a time out. We want to destroy the very item that we've been trading on falsely for 18 months to do mitochondrial DNA testing, which, as Mr. Lally indicates, he's smart enough to know, the lab is smart enough to know that's completely destructive testing. That will be exhausted, it's gone after the mitochondrial DNA is done. I expect that Mr. Lally will say something along the lines of, well, we were just trading on the idea that Maureen Hartnett at our crime lab microscopically confirmed that it was a human hair. And she did. What's the problem with that? She failed her proficiency exam the month before she did the examination on the exact same issue.
You hear the crowd.
On the exact, and it's not
Everybody laughs. I love this. Let's back up a little bit. You hear everybody laugh.
hair. And she did. What's the problem with that? She failed her proficiency exam the month before she did the examination on the exact same issue. On the exact, and it's not like a generalized proficiency exam. It's a proficiency exam dedicated or focused on whether or not she can microscopically determine a human hair. And she failed that. So they have Maureen Hartnett saying it's a human hair. She's not even qualified to say it. Then they go back and DNA test it. It comes back not to be a human hair. Then they say we want to destroy it. My position is it should not be destructively tested, certainly not by the Commonwealth. I understand, I know the Bodie outfit in Virginia, the third-party outfit. They've got a good reputation. However, before anybody gets their hands on that hair, I don't even know if it is a hair, quite frankly. Before they get their hands on that item and destroy it, I would ask that that item be made available to us. This protocol is undertaken all the time throughout the country. Have it sent to an expert of our choosing, and we have one in mind out of Chicago, probably the most well-reputed microscopic analysis shop in the entire country. We'll have them employed to look at it microscopically, make their own determinations. At that point, Mr. Lally, myself, we can agree if, in fact, the results are satisfactory to have it exhaustively tested, but certainly not now, not after this, as I said, tortured history of this item.
Real quick, Christina, thank you so much for the $5. She says, what the WTF? I'm outraged all the way in Idaho. Ramos, thank you so much for the 5 on PayPal. Let's see. 5 on PayPal. Thank you. So we had 5 and then 5. Let's add that. Thank you. Appreciate that. Thanks for the support.
Okay. So am I going to hear from Mr. Lally or Ms. McLaughlin, who wrote Mr. Lally, I'll hear from you.
Your Honor, as it pertains to the hair, so the analyst responds to the garage of the Canton Police Department labels it as an apparent human hair based on the characteristics that she observes when she removes the item. The item is then taken back to the lab and microscopically analyzed. There are photographs that counsel has from the lab packet that's already been provided. I would submitting any of those photographs to whatever expert they want. I would imagine would concur with Ms. Hartnett's analysis based on those characteristics that it is a human hair. I believe what has just been stated is a complete misrepresentation of what that DNA testing
thanks for the
report says.
$8
What
on
DNA
Cash
testing
App.
report
Appreciate
says
that.
is that there was no human DNA detected. As the court is well aware, there are essentially 4 steps that are done in a short tandem repeat DNA analysis. The second step being quantitation. So when there is an insufficient amount of a sample, and that's why the root end of a hair is the one that's initially tested for DNA, because you're not getting DNA
So close to getting to the $100.
typical DNA testing from the actual strand of hair. You're using the root end in the hope that there are some residual skin cells that are left from profile from. That's what no human DNA detected means, which I'm sure counsel is well aware of in its representations to the court to the contrary. So the SCR analysis is not done on the root end of the hair because there is an insufficient sample for them to even replicate in that quantitative second step. So the findings from the criminologist or the criminalistics expert as a microscopic evaluation of that particular item and identifying it as a human hair is not incongruous with the finding from the DNA that there was no human DNA detected on that particular item. So as far as this particular item being sent, we're not looking to destroy the item. It's based on the item's size that any further DNA testing is going to exhaust the sample. We're sending it to an outside lab, to an external vendor, and that external vendor does provide for some opportunity for the defendant to send an expert to observe said testing. So there's nothing that's being hidden here or kept from the defendant. All items as far as that microscopic analysis are concerned, lab notes, photographs, everything pertaining to that has already been provided to counsel. All of the testing results have been provided to counsel, and we're asking for it to be, for the court to order or allow or permit it to be sent to this external vendor to conduct this
I need a
testing,
hand puppet.
and bring in
Better
the
if I hand
report
puppet.
because of their observation policy and because of the likelihood of the exhaustive nature of the testing.
If the testing is to occur, did they give you a timeline as to, I'm going to hear from you in a minute, Mr. Jackson. I just want to know the answer to this question. Did they give you a timeline as to how quickly that could occur?
I believe 2 months or so is the estimate that I got.
All right. I'll hear you now, Mr. Jackson.
2 months.
At the end of the day, all we're asking for is to have the
I know. I need a sock puppet.
item reviewed microscopically that has nothing to do with any destructive testing whatsoever. It's going to be reviewed microscopically by somebody who actually knows what they're doing. And my problem with Mr. Lowley's response, and I understand why he's responding this way. Well, there's no deception here. We weren't pulling the wool over the court's eyes or counsel's eyes or anybody else's eyes. It looked like a hair. Why didn't they say that? Why didn't they say it looks like
Beck, $5 Aussie. Thank you. Look at this. Australia checking in tonight. It says log on to see straight up Muppet Hand Lally impersonations and made my day is complete. Thank you. I appreciate that. I got to get a puppet. Next time I'll make a puppet. I'm going to grab a puppet. So when Lally's speaking in these next hearings, I can just make a puppet hand. I'm going to look and try to buy a puppet off Amazon tonight. I'll have a puppet next time we do this. I love it. All right, let's keep playing through here.
hair?
Thank you all for being here.
As established-
Thank you all for being here tonight. I appreciate it. Thank you for being subscribed to LTL, and I appreciate it. Do we get to 1,000 likes yet? Yeah, I need like a sock puppet. Another Aussie checking in. Joe, thank you. Says $20 Aussie. Love it. Says Brian, thank you for all your humility and honesty, brother. These pretrial hearings make the setup theory even more validated. Love from Tasmania. Good eye, Mike. Australia, my man. My sleeping patterns are forever altered after this trial. I love it. Oh, great. We got to 1,000 likes. That's fantastic. Good stuff. Now we can get people in here, and now we can get more people in here and know about what's going on in the Karen Read case. You know, they need to be educated. That's why we go back and we look at these pretrial hearings. Because I tell you, a lot of people, you know, there's a lot of new people that just came to this channel or came to this trial, and they haven't seen all these pretrial hearings and the setup. And this is important to go over so you all understand how much discovery and evidence was not let in by this judge, how biased she was towards the Commonwealth, with the Commonwealth, and how biased she was towards the defense. All right, let's keep playing through here.
Established by our expert who failed her proficiency examination. That would have been a truthful statement. But the statement that they've repeated over and over and over to this court.
Yeah, I've been trying to work out.
Under oath.
Nick lives a little bit far from my studio, but I definitely think that we will get Nick in here sometime, and Kelly Reed, I would love to get in here sometime to have a conversation, down the road. She's dropping her link in the chat right now. Kelly, did you get to 30,000? I want to see where you're at. I'd love to get Kelly in here sometime for conversation, get Nick in here. I know Scott has, so you're at 2952. Let's do this. Where are we at for a total right now? Rogue, where are we at for total? Let me see where we're at. Yeah. Let's see where we're at. Just waiting for Rogue to give me a total. 352. 352. 25% of that is 88. We're close to 100. Why don't we do this? Let's do this. I wish I could just make like a straight donation. All right, if we're not at the end, I'm going to put tonight's 25% towards Kelly's popcorn. We'll get it to 30,000. Yes, Kelly, anytime. We'll just set something up. Scott's had some interest. I'd love to get Scott in here. Paul Cristoforo, everybody. They're always welcome. Everybody's welcome. We got to see. Oh, by the way, look at this. Oh, speaking of, check this out. Got the new lens. So once I get all these lights out of the way, we're going to relight the studio with ring lights. And look, you'll be able to see someone actually sitting next to me and I having a conversation with them. So we're going to relight the studio. I got the 13 millimeter lens on there. I told you it would open up and bring everything up a little bit more. And, we'll do a shot like this, a single shot on me. And then you can see the guest sitting down over here. We're going to get this all relit in here with ring lights. I'm going to end up probably losing these long lights here. The studio lights will come out of here. Again, trial and error, things that you buy, things that you need, things that you don't need. It is the way it is, but we're learning through this process. And I think with some nice ring lights in here, it's going to set everything up. So I can make you look, 10 years younger, Kelly. Don't worry. I will light you perfectly. But yes, I would love to have you come in. And Scott, yes, you are welcome anytime. I got to start getting these people in that have been part of the movement. I want to sit down and actually talk to them and have like a human conversation. But we'll get there. Don't worry, Kelly. I will light you perfectly. All right.
Perjury is the hair has been forensically confirmed. There is you can't word salad your way out of that. Forensically confirmed means it's been DNA tested.
You bring this back up. Bam. Oh. What am I doing?
Forensically.
There we go. Sorry, everybody.
And there is no human DNA.
Oh, I did it again. Son of a bitch. Sorry.
Hail Mary to try.
Oh my God, I did it again. I'm trying to stop the extra camera. There we go.
One in front of the Court of Appeal. It just doesn't pass the
Sorry,
smell test.
everybody.
What we're asking for is very simple. We can address the mitochondrial destructive and exhaustive DNA testing at some point down the road.
Okay.
We want access to that item so that we can confirm.
We got a bunch of cash apps that came in. Let's see. I don't want to screw this up. So Irene, thank you for the $10. Oh, I got that one already. John with the 8. Okay, we got that. Rogue Townie with 20. Thank you so much. So we add 20. And then John just sent $48 via Cash App. Thank you, John. And Sarah just paid me 60. So we'll add that. And I think I'm just going to do this. Let's just do this. We're at Kelly needs. She's at 29,967. Let's just make a donation right now to put her over the top. I'm going to buy one of the perfect 10. So that's 115. Let me check out here. All right, I'm going to keep working on that, and we're going to get Kelly over the 30,000. I'm going to keep playing, and I'm going to work on that right now while we do that.
Whether or not it's even microscopically been properly analyzed. That's all we're asking. And I'll submit.
Can you get me an affidavit from your expert as to why photographs are not sufficient?
I can, and I can, as an officer of the court, I can certainly indicate to the court that this has been done enough. I'm experienced enough to know that they can't do it vis-a-vis even a micro photograph. They have to see the item in person, but I can get a declaration to that effect.
And how the procedure would be conducted and how long it might take. Put all of that in writing for me, and I'll consider it when I consider this motion.
Thank you, Your Honor.
All right. So we'll move on to Mr. Yannetti's motion as to why I should change the
credit
conditions.
card
for
so I
these.
can make a purchase. No, I'm not giving anybody the numbers.
May it please the court, I appreciate the opportunity to be heard. Your Honor, I stand before you because it is in the interest of justice for this court to lower my client's bail to personal recognizance in exchange for Ms. Reed turning in her passport and signing a waiver of rendition. We make
Okay.
this request because there are numerous
So everybody
important
knows,
change
get the
circumstances
LTL
that have
credit
come to
card
light
out.
since bail was last considered and modified.
do this.
We also make this request because my client's finances continue to be drained and depleted as she struggles to pay the multiple experts she needs to properly defend herself in this case.
So before we go any further, I saved this motion to the end because you indicated that I would have an affidavit from your client as to her finances. I do not have that.
Yes, I did not file that electronically.
All right,
But I still don't have it now.
I have it in my hand, Your Honor.
So that doesn't help, does it, Mr. Yannetti? I need to read it.
No, I'm happy to pass it up.
Damn.
Just give it to me and let me
Got
read
it.
it.
Gotti. So I just don't want to dox myself here, but just so everybody can see. Oh shit, I'm gonna dox myself. Hang on. Let's just widen that up. And just so everybody knows that I did make the donation live on air. Let's see. Let's do this. And we made the donation. So that should get her over the top. And good stuff there. So Kelly, congratulations. Hopefully we got you over the 30,000. Let me just update here and go back to Kelly's fundraiser. Let's see. Yes, we got it. Yeah, baby. Woohoo! I love it. I love it. Good stuff. All right, let's go back to the hearing. No, don't subtract my 100. Just keep the rolling total when I call it out. Don't subtract anything. We'll just kick that up to Karen.
All right, so give me a minute before I hear you.
$15
Has
on
Commonwealth seen
Cash
this?
App. Please
I'm
add
filing
that.
it ex parte. So no, I-
Hanson, thank you. Cool. 30,000. Awesome. Thank you, Pokey. And Kelly just confirmed with me. She just sent me a text. Well, Brazilian, listen, we don't ask you to be here, and I'm going to tell you right now, you're not going to tell me how to run my show. This is my show. I understand you're a member. I understand you support my show, but this is my show. And if I can help someone get over a goal, if I can get someone to eclipse over that $30,000 for Karen, my voice just cracked, I'm going to do that. If you don't like it, you don't have to be here. You don't have to watch me. You can unsubscribe and leave. But no one's going to tell me how to run my show. I run my show the way I want to run my show. And everybody knows this is live. And I will do what I want on my platform. So if I want to stop it and do something to help someone out and give money back to someone to help their defense, I'm going to do it. All right, let's keep playing.
All right, so Mr. Mr. Yannetti, you've seen, I imagine, in your time as a prosecutor too, you've seen affidavits of indigency.
Yes.
But this doesn't give me enough information.
Well,
Doesn't give me enough information on DeBrangan, doesn't give me enough information at all.
My client has expended multiple, fees to not only experts, but also to lawyers prior to the last date as well, Your Honor. In terms of qualifying as indigent, I would argue that we have a little bit of a different situation here. Generally speaking, somebody qualifies as indigent because they can't afford an attorney, they can't afford any experts at all. That's not what we're saying. What we're saying is there's an overwhelming financial crush with regard to this particular case. That and there are also, I should say, many more expenses to come. Many of which have been already discussed by this court with regard to the multiple experts.
Do you want the opportunity to file a proper affidavit on DeBrangan? This doesn't give me the information that you know that.
We're happy to do that, Your Honor. I would still like to make my argument today.
Okay, you can make your, I can't make the findings on DeBrangan,
Right,
Mr.
well,
Yannetti.
but at the end of the day, Your Honor, if it's supplemented by an affidavit, then the court can make a finding at that point.
Okay, I'll hear you since you're here and you're ready, and we're doing a great job with
Kelly,
timing.
you
I
didn't have to
appreciate
super
counsel
chat.
lobbying.
Thank you though so much. So thank you everyone. I'm so proud to be able to help Karen with all of you. We're so happy to help you, and we're so happy to help Karen. And anything that we can do to help the Reeds, we want to do that. You know, I've only had the opportunity to meet Karen once, but I knew that I would continue to fight for her because, you know, I talked about this on the show yesterday. She hasn't faltered once through any of this. She has been a statue, a pillar. She hasn't shown that once in any time in public. And the strength that is inside that woman that comes out just pours through all of us. And I've made the commitment here. I will continue to fight for Karen Reed on this channel until her name is free and clear and she can go on with her life. So you got me. I'm here. And I know there's many other people out there that will be along for the ride. So we got you. We got you. Don't you worry about that. All right, we got about another 30 minutes or so to wrap this one up. Appreciate everybody being here this evening. And thank you for all of your support, all the popcorn that you've bought through whatever avenue you wanted to, whatever person you wanted to buy it through. And I appreciate all the support here on LTL and giving back to Karen's Defense Fund. All right, let's go.
I appreciate that, Your Honor. Just continuing with my train of thought, the $80,000, our argument is sitting in the Norfolk Superior Court clerk's office now serving no purpose other than to prohibit my client from using that money to properly defend herself.
Bev with the side.
Your Honor, every time this bail has been discussed regarding this matter, both in Stoughton
Patty,
Court and in this court, the Commonwealth has consistently maintained that their only justifications for requesting bail are, number one, the potential penalty my client faces, and number two, the nature and circumstances of the case. With regard to with regard to both, I'm concentrating my argument on changed circumstances. With regard to the potential penalty, in light of the changed circumstances that have and will be discussed during this argument, in light of what we've learned since the last time bail was modified, we believe, and my client well knows, the potential penalty she faces is nothing. There will be no penalty here because there will be no conviction. There will be no conviction because the evidence establishes her innocence. There's no jury anywhere who will ever vote to convict her for a crime she did not commit. And that leaves us, Your Honor, with a bail argument that relies really exclusively on the nature and circumstances of the case. And the nature and circumstances of the case, as represented by the Commonwealth during its numerous bail arguments regarding this matter, have been shown to be false. It is a fact that the nature and circumstances of this case have completely changed, even since the last time this court modified her bail. The nature and circumstances of this case, in fact, are night and day from what was presented to Judge O'Malley in Stoughton District Court at my client's arraignment there over 19 months ago. At that arraignment, Your Honor, having read only the scant information that the Commonwealth made available to me, it was still immediately clear to me that this case was a tragedy but not a crime. From the very start, with most of the evidence hidden from the defense, the Commonwealth's case against Karen Reed was extremely thin. And from the start, she had no reason to flee. because even without the results of our investigation, her defense was strong. And it was strong because it was based on innocence. By the time I got back to my office that afternoon, I had already begun to learn that this wasn't just a tragedy, and it wasn't just that my client had committed no crime. But shockingly, at the time, I learned that somebody else did, in fact, commit a very heinous crime. A friend and colleague of Brian Albert's called me on February 2nd, 2022, only hours after my client was arraigned, and named Brian Albert and his nephew Colin Albert as potential suspects. That tip on day one of this case led us to do the investigation the Commonwealth did not do, the investigation they refused to do. And as my co-counsel has argued today, that investigation revealed that the Commonwealth's investigation was based on one lie after another. And the exposure of those lies is a major change circumstance, which justifies lowering my client's bail to personal recognizance. I'd like the court to consider that at the outset of this case, State Trooper Michael Proctor submitted a report stating that Fairview Road in Canton had not been plowed during the early morning hours of January 29th, 2022. He claimed in that report that Michael Trotta at the DPW had told him during a phone call that he had with him after John O'Keefe was killed. We did not take Michael Proctor's word for that, and thank God we didn't, because we learned that was a lie.
Wow.
Rather than take Michael Proctor's word, we instead sent our investigator to speak to Mr. Trotta in February of 2022. He directed us to another man who led us to the plow driver who did plow the street. Our investigator interviewed plow driver Brian Laughlin within a couple of weeks of John O'Keefe's death. Mr. Laughlin told us what he has now told Michael Proctor, now that Proctor finally got around to speaking to him a year and a half after the fact. Shortly after John O'Keefe died, Brian Laughlin told us that he did plow the street in front of 34 Fairview, made a pass by there at 2:30 in the morning on January 29th. And when he passed that house, there was not a lot of snow that had fallen. Visibility was good. The lights were working on his plow. He passed right by the area where John O'Keefe's body would have been if Karen Reed had actually struck him with her vehicle. And he confirmed that at 2:30 a.m., plowing that area, there was no body there.
Boom.
And Mr. Laughlin was firm with Trooper Proctor. There was no body. And he told him not only was there no body, but if there had been a body there, he would have seen it. He left Michael Proctor in the Commonwealth no wiggle room. The plow driver's testimony should end this case. To put it simply, no body at 2:30 a.m. means Karen Reed is innocent. Forget about all the other evidence that points to her innocence, but this one fact alone prevents the Commonwealth from ever convicting her. No body at 2:30 a.m. She is innocent. But Your Honor, it's not.
I see you. $50 says great videos. Keep them coming. Always. Always, always, always. You know what's crazy? And just to kind of deviate from Karen Reed's case, I wish I would have covered that Young Thug case, because I think a judge got thrown off that case today. That case has been freaking wild, like insane, everything that's gone on in that trial. I literally wish I would have followed that case. It has been crazy. But yeah, it's nuts. So nuts. And I knew the Alec Baldwin trial. I said this. I said, man, I should follow it. And I didn't. But I knew something wild was going to happen in that. I knew something was going to happen, and it did. Something happened. All right, let's keep playing here. We got about another 25 minutes.
Not just that he saw no body at 2:30 a.m. After that, he saw a Ford Edge parked right in the area where John O'Keefe's body was later found. Whoever moved that Ford Edge to that location in the early morning hours of January 29th, hours after Karen Reed left Fairview to go home, that person or persons knows exactly what happened to John O'Keefe. That mysterious driver and his or her accomplices likely know who beat up and killed John O'Keefe. And that person knows how John O'Keefe received all of the scratch marks and bite marks to his arm. This is all brand new information to you, Your Honor, as you did not have the benefit of any of this exculpatory evidence when you were deciding on an appropriate amount of bail. Frankly, when the Commonwealth...
No, right here, I'm reading the headline. Judge kicked off, preserving the public's confidence in the judicial system. Judge kicked off Young Thug RICO case after improperly defending himself against recluse. Oh my God. That case is insane. I wish I would have followed it. That thing has had everything in it. All right, let's keep playing here.
On the nature and circumstances of the case in order to justify bail being set. Those nature and circumstances have changed in such a fundamental and drastic way that I'm surprised the Commonwealth is opposing this motion. When you set bail, you did so in part on a representation by Mr. Lally at my client's arraignment that there was that apparent hair on the rear passenger side quarter panel of my client's Lexus. We now know that Mr. Lally relied on the gross examination performed by a criminalist who failed the proficiency exam in performing gross examinations of evidence. We now know from the Commonwealth's own testing that not only did the hair not belong to John O'Keefe, it turns out it wasn't even a human hair. That is a significant change circumstance from what was represented to you by the Commonwealth, and that would justify lowering her bail. When you last set bail, Your Honor, you had no idea that one of the Commonwealth's main witnesses, Jennifer McCabe, who had been at Brian Albert's house on the night in question and would have had to walk by John O'Keefe's body in the yard if it actually was there at that time, went home and at 2:27 a.m. Googled Hustlong to die in cold. You did not know when you set bail that Jennifer McCabe deleted that Google search. We have stressed to you ever since that our expert.
Oh, and by the way, Jen McCabe's trying to get a big rally going for the 22nd. They're saying something about selling T-shirts today, $15 blue T-shirt to support John's family, $15 T-shirt. So I saw some posts about that today. These people are sick. I mean, they're literally like partaking in killing John, and they're going to keep showing up at these court hearings. And they're absolutely insane. They're crazy people. It's disgusting. So we'll see what happens on the 22nd. I see you. Thank you so much for becoming a new YouTube member. $5 to the total, please. All right, let's keep rolling through here.
That
We're almost
search,
finished up.
but we stand ready to prove beyond a doubt that Jennifer McCabe did it at 2:27 a.m. Our expert
Oh, absolutely, Scott.
And importantly,
They're just
the Commonwealth
insane. They're
handpicked expert,
psycho.
Ms.
They're
Hyde,
psychopaths.
confirms that the timestamp was 2:27 a.m., but says that the reason is unknown. This is all new information that you did not have when you have set bail in this case. And it
Tina,
goes
thank you
without
so
saying,
much.
Your Honor,
$10.
that Jennifer McCabe's Google search, trying to determine just how much time had to pass before
Thank
John
you.
O'Keefe would die in the cold, is completely consistent with her guilt or complicity in this crime and completely consistent with my client's innocence. You did not know this, Your Honor, at any time that you set bail, and this is a changed circumstance justifying a reduction. This is on top of the lies that have been uncovered. Not only did Proctor lie about the plowing of the street, not only did Mr. Lally represent that a human hair was found on my client's car when it wasn't, but importantly, Your Honor, you have been lied to by Brian Albert. In opposing our motion to get the animal control records, Mr. Albert's attorney told you that Mr. Albert's dog, Chloe, had no history of attacking human beings. Thank goodness you ordered the records, Your Honor, because we learned that was a lie.
Yeah.
To be clear, I do not believe for a second that Brian Albert's attorney, Greg Henning, would lie to this court. That leaves only one possibility. Brian Albert lied to him. Brian Albert told him that Chloe had never attacked a person. Brian Albert was desperate to keep these records secret from the defense and was willing to lie to keep them secret. The fact that those records have now been brought to court and revealed that Chloe attacked not just one, but two people in the past, sending them both to the hospital, is a major change circumstance. Brian Albert lied, which is powerful evidence of his consciousness of guilt. You should have been able to consider that before you set bail in this case, but that information was kept from you. It is now yet another change circumstance that justifies the lowering of Ms. Reed's bail. Now, I expect that the Commonwealth will argue 2 points in opposing this motion, both from lab reports. One, that John O'Keefe's DNA was found on my client's Lexus, and two, that there were microscopic pieces of taillights supposedly found on his clothing. Both of these arguments are red herrings. Regarding his DNA being found on the vehicle, our response is, of course it was found on the vehicle. It would have been shocking if John O'Keefe's DNA were not all over that vehicle, on every part of both the outside and the inside of the vehicle.
Cindy,
he was in the
thank you
vehicle
for
that night.
$25 on Buy Me a Coffee.
He was around
Thank
the
you.
outside of the vehicle several times that day and night.
Long
That vehicle
time
was parked at his
supporter of
house
the
for
channel.
months.
Thank
He
you.
lived with the owner of that vehicle. It's completely unsurprising that his DNA is on it. That finding does not undercut the new and powerful exculpatory evidence of no body being found in the yard at 2:30 a.m., a Ford Edge being near the yard where the body was later found after 2:30 a.m. Give Jennifer McCabe Googling how long to die in cold at 2:27 a.m., and then 3 minutes later, Brian Lawfern driving by 34 Fairview and confirming no body there. Regarding the tiny pieces of taillight, for those to have any evidentiary value, you have to trust the person who had custody of John O'Keefe's clothing before it was sent to the lab.
So, Ms. Little, I'm not looking at any, if you show them to the audience before you show them
Sorry,
to me,
Lab.
I'm not going to look
Look
at
at Liz just laughing at her.
Okay, please put that down.
Look at
Ms. Dianetti, do you have chalks for your bail? Please put that down. Do you have chalks for your bail argument?
I have one chalk that I was intending to show the court at the
So
appropriate time.
I don't need to see
Look
a
at
chalk,
TV.
Mr. Yannetti. You didn't give me sufficient evidence under Commonwealth versus Brangan.
Well-
So I will hear you because you want to make this statement. So go ahead, but no chalks.
Wait, Your Honor, just so we're clear, it's not.
Sonny, what would you like to speak about? You can email me. Why don't you email me? And there's my email right there. Let's talk live podcast at gmail.com. What would you like to speak about? Send me an email. I'll try to get back to it as best as I can. But thanks for being here. All right, let's keep playing.
Not just her financial status that justifies reducing the bail. The thrust of my argument is all with regard to changed circumstances.
I understand that, so I'm going to let you continue. But a very important piece of this is missing. So go ahead with your argument. No chalks, please.
And obviously, my argument is, leaving the financial issues aside, the bail should be lowered based on my argument here today that I'm making to this court. I had just said.
Pilgrim
stated, Your
Shadow,
Honor,
thank
that
you.
In order
$10.
for that, the
you
microscopic
as well.
supposed pieces of taillight to have any evidentiary value, you have to trust who had custody of them, which means that you have to trust Michael Proctor. And I question, how on earth can anyone trust Michael Proctor?
Yeah.
I've previously referred to him as being conflicted, which is certainly true, but it actually does not go far enough to describe what he has done in this case just by taking the case. The more appropriate word to describe him is corrupt. Only a corrupt state trooper would agree to investigate a murder case in which a body was found in the yard of a family friend. Only a corrupt state trooper would keep his ties to that family friend hidden. Only a corrupt state trooper would refuse to go inside the home, which featured the body of a dead police officer on its lawn. Only a corrupt state trooper would write in his report that his street had not been plowed when it had. It was the corrupt Michael Proctor who took custody of John O'Keefe's clothing, and that clothing was not submitted to the lab until several weeks after Michael Proctor seized it. You, I believe, have seen the chalk, Your Honor. That chalk shows that Michael Proctor is at the hospital. John O'Keefe's body is on a hospital bed. You see Michael Proctor's feet, and at the bottom of his feet, you see a pile of John O'Keefe's clothing, unattended, sloppily thrown on the floor. That's the care with which Michael Proctor treated what they now claim is important evidence. And that clothing
Thank
was
you,
not
Danielle.
submitted to the lab,
Appreciate it.
Your Honor,
Thank you.
until after Michael Proctor had seized my client's Lexus, and therefore seized pieces of the taillight. And you should consider how he treated the evidence afterward as well, in terms of not sending it to the lab until March of 2022. He had it for weeks. Michael Proctor's mother has described the Albert family as the Proctor's second family. Michael Proctor told witnesses who showed up to testify before the grand jury that Brian Albert is the salt of the earth. Michael Proctor's wife has posted about how much they love Colin Albert. The Proctors have constantly been photographed with the Alberts going back over a decade. We've shown that Michael Proctor's at a wedding party with Colin Albert. Colin Albert was the ring bearer at Michael Proctor's sister's wedding. It's so clear that Michael Proctor was both conflicted and corrupt. He had every reason to sprinkle tiny pieces of taillight that he had seized into the clothing that he alone took, so that the lab would later find it weeks later, and sure enough, they did. And this supposed discovery does not undercut the fact that Jennifer McCabe Googled how long to die in the cold at 2:27 a.m. and Brian Laughlin went by and saw no
You're right, Jody.
body outside that house 3 minutes
100%.
later. So legally, you have all the support you need to release my client on personal recognizance. There's also a practical side to this, which gets into the financial issues, Your Honor, and I'm almost concluding my argument here. You've seen my client's medical expenses in the past. You've been aware of her loss of income. You've also been aware of the numerous experts, witnesses, investigators we've had to retain to do the job that the Commonwealth either failed or refused to do. Those expenses continue to mount. She has not asked this court for a dime to pay for any of those expenses. We're now approaching a trial date, which we will request today. Those expenses continue to mount and indeed will skyrocket. She cannot afford to skimp on these experts. The stakes are too high. She needs every dollar she can to keep going, and $80,000 is a lot of money that will go a long way toward supporting her defense. To make it clear, Your Honor, we are not making this request without offering something in return. I would submit there's nobody in this courtroom who believes my client is a flight risk. Given the national publicity that this case has generated, which I submit will only intensify as we approach a trial date, my client is one of the most recognizable criminal defendants in America. Where on earth would she go, even if she wanted to go somewhere? But she's not going anywhere. Her family's here, her doctors are here, and given the strength of her defense, as illustrated by the changed circumstances we've discussed, she has every incentive to fight this case and no incentive to flee. She's made every court appearance and has invested herself 100% into this case, financially, emotionally, and intellectually. But if there's any concern at all, Your Honor, my client will dispel those concerns by turning in her passport. I have it. She's ready to give this to the probation department. She's ready to save sign a waiver of rendition, any waiver of rendition the court would desire. So on this issue, she's really figuratively putting her money where her mouth is. Giving her passport and a waiver of rendition is far more valuable to this court in terms of assuring her
Nettie,
appearance in
pulling
court than $80,000 is. But that $80,000 is more valuable to her because she desperately needs it to defend herself. So for these reasons, Your Honor, I ask that you help us to level the playing field here. The Commonwealth has unlimited resources. My client does not. I ask that you release her on recognizance and give her the tools she needs to fight this case.
All right, thank you. Do you want time to provide that affidavit to me?
She just ignores it.
Okay,
thank you. All right. Okay. Thank you. Okay. All right. Thanks. Move. All right. Do you want time to respond? She's almost like helping Lally. Do you want to respond to that? Okay. Thank you. All right. Well, okay. All right. So what? Who cares?
Quickly, can you do it?
We have 1 week.
Okay, yes. Mr. Lally?
Just very briefly, Your Honor.
Okay. Yeah. All right. Sure.
The Commonwealth just requests that the bail remain the same. There's no change in circumstances of the facts, and I use that term loosely, as Mr. Yannetti was recounting for the court.
Ridiculous.
Notably absent from his motion in regard to the apparent hair, which I've gone into great detail to explain. I won't bore the court with that explanation again. But what it leaves out is, again, yes, as counsel was alluding to, there were 2 items that were tested for DNA, one of which being the taillight housing. Just to be clear, the taillight that was within the defendant's vehicle, which was then compared to the DNA of the victim, Mr. O'Keefe, and that there was a significant statistical probability of comparison between Mr. O'Keefe to a number followed by 30 zeros that Mr. O'Keefe's DNA was on the taillight. The same taillight was broken when the defendant struck Mr. O'Keefe with her vehicle. Now, as far as what counsel states as Mr. Loughran's testimony goes into great detail in the motion as well. What he leaves out, though, is that all these insinuations that the Ford Edge somehow belongs to the Alberts or Brian Alberts' Ford Edge or something to that effect. What he leaves out from that interview with Mr. Loughran is that Mr. Loughran specifically says that Ford Edge is not Brian Alberts' Ford Edge. Another sort of interesting issue in relation to the affidavit from the investigator in regard to seeing that Ford Edge and his label as such is that the investigator essentially takes Mr. Loughran out to the parking lot, points to a Ford Edge, and essentially says, "Is that it?" Somewhat suggestive identification of that particular vehicle, the Commonwealth would suggest. There is simply no evidence of Trooper Proctor having a close connection with the homeowners. There is simply no evidence. Whereas, I guess now it's being positioned that he was.
Wow, that really rattled. That's funny. That rattled Lally. I want to watch that in real time. Let's take that down to real time.
Particular vehicle, the Commonwealth would suggest. There is simply no evidence of Trooper Proctor having a close connection with the homeowners. There is simply no evidence. Whereas, I guess now it's being positioned that he was sprinkling tiny pieces of a taillight, pieces that I described to the court earlier as less than 1/16 of an inch that were embedded within Mr. O'Keefe's clothing. I'm not going to go over again and again the issue as far as Ms. McCabe's search on her phone. The court has been provided numerous reports from forensic experts disputing whatever Mr. Green's findings are. Counsel seems to want to choose or pick and choose as they do with each particular piece of evidence or each report as to what they want to highlight. But the conclusions from Ms. Hyde's report are clear that from her analysis of that search was conducted respectively at 6:23 a.m. and 6:24 a.m. It is not a mystery as to when that search was conducted or why that search was conducted. It was conducted by Ms. McCabe at the bequest of the defendant. As far as anything pertaining to Ms. Reed's financial resources, again, those were filed ex parte. And as the court, I really can't
get a
speak to
hand
those.
puppet.
All I can speak to as far as financial resources is this case was initially arraigned in the Stoughton District Court. The court set a cash bail of $50,000.
The hand
The
puppet.
defendant posted that within minutes. The defendant was then arraigned in this court. The court set a cash bail of $100,000 initially at arraignment in June of 2022. That bail was posted within
Oh, I
minutes.
got one.
If the court
I
is
got a good
inclined to reduce the cash bail,
I got a good
don't
hand
think it's
puppet.
of much moment to the defendant, Ms. Reed. But if it were, I would ask that some additional conditions be set in place, similar to what I had asked for previously on the February date. If the court were inclined, I would concur with surrendering a passport. I would concur with executing a waiver rendition, and I would ask that there be an additional order the defendant be ordered to remain alcohol-free, subject to random testing with a SCRAM device, based on the nature of circumstances and based on the indictment she faces in this court. Thank you.
Okay,
If I may respond briefly to 2 points, Judge.
okay.
Your Honor, first, with regard to the DNA being a match or a presumed match of John O'Keefe.
Marcy, thank you so
what
much.
Mr. Lally
Lally
will tell
know
you
what
is
he's-
that sample was a mixture of John O'Keefe and 2 unknown
Oh, it's so
people.
good. $10.
So I
Thank
don't
you.
know if the Commonwealth is changing its theory again to say that my client struck John O'Keefe and 2 other people, and the other 2 people somehow got away. But that doesn't make a whole lot of sense. The second thing is, with regard to the Ford Edge that Brian Laughlin saw outside that property, I would say 2 things. Number one, assume it was not Brian Albert's Ford Edge. It doesn't matter because there was somebody there outside the property where the body was found after 2:30 a.m. They would have either seen or not seen a body and known or not known that there was a body there. But finally, with regard to that point, Mr. Laughlin was clear that it was not Brian Albert's Ford Edge. What he did not tell you, what Mr. Lally did not tell you is there's another member of the Albert family that has a Ford Edge, and that's Colin Albert.
Oh. Oh.
So, Ms. Bianetti, I need that affidavit by next Friday, so I'll put this motion under advisement. All right, so I said at the beginning that we need to set dates, and it's been mentioned that there have been a couple of pretrial conference dates. There have, but council have not complied with the Superior Court standing order that we need to get back on track. So Superior Court Standing Order 2-86. So we need to set some dates. And council has to comply with Rule 11 of the Mass Rules of Criminal Procedure regarding the pretrial conference. So I'm going to give you a date for you to fill out the pretrial conference report and do everything that you're supposed to do pursuant to Rule 11. We need that before we can go any further. And in that report, you need to outline dates for filing of motions. So I have some suggested dates, given that we were able to work out the discovery issues today. So I think all non-evidentiary motions in this case must be filed by November 16th. I don't want any more piecemeal Rule 17 motions. If there are piecemeal Rule 17 motions, you need to put in the affidavit why those weren't handled when they're supposed to be. I would like January 5th for filing all evidentiary motions. And February 15th for a pretrial hearing, final pretrial hearing. And you say that you have proposed trial dates. What are your proposed trial dates?
Gonna push it.
Your Honor, it would be the defense
You want me to
request.
play that
and we're
again?
open to the specific date, but we would like to try.
You want me to play it again? Or you want us to play it again? All right, I'll replay it.
Your Honor, first, with regard to the DNA being a lot of sense. The second thing is, with regard to the Ford Edge that Brian Laughlin saw outside that property, I would say 2 things. Number one, assume it was not Brian Albert's Ford Edge. It doesn't matter because there was somebody there outside the property where the body was found after 2:30 a.m. They would have either seen or not seen a body and known or not known that there was a body there. But finally, with regard to that point, Mr. Laughlin was clear that it was not Brian Albert's Ford Edge. What he did not tell you, what Mr. Lally did not tell you is there's another member of the Albert family that has a Ford Edge, and that's Colin Albert.
Oh!
So, Ms. Giannetti, I need that affidavit by next Friday, so I'll take this motion under advisement.
I love it.
All right, so I said at the beginning that we need to set dates, and it's been mentioned that there have been a couple of pretrial conference dates. There have, but council have not complied with the Superior Court Standing Order that we need to get back on track.
A little bit.
I would like January 5th for filing all evidentiary motions. And February 15th for a pretrial hearing, final pretrial hearing. And you say that you have proposed trial dates. What are your proposed trial dates?
Your Honor, it would be the defense request, and we're open to the specific date, but we would like a trial date in March of 2024.
Okay, that's great.
Early March would be better if it's available.
So we have a trial that's starting in January, a retrial that last time took 6 weeks. So I think mid-March would be better for us.
Okay.
Jim, can you suggest dates?
Yeah, how is March 12th? 12 or 19?
12 would work. Is the court's preference, just going by what Mr. Jones said, we start on Tuesday.
Yes, we typically do Tuesday.
Yeah, because civil and panels on Monday.
Makes perfect sense.
Yeah.
Does that work for the Commonwealth as well, March 12th?
Yes.
So,
fine.
as a result of that, can we have a final pretrial conference sometime the end of February? Maybe 26, 27, 28 in that time frame? Is that week good? Oh, I'm sorry. Yeah, go ahead.
It's good for me. I just want to make sure it's good for me.
Teresa, thank you for the $9.99. Please keep those looking back videos coming in. I'm beyond outraged. Yeah, we'll keep doing it here. We're going to make it a theme here on the channel until the 22nd. So we'll keep
26th,
playing through these. This cat.
That's a Monday, we can do that. That'll be at 2 p.m.
Yeah, we're going to keep doing this here.
Yeah, and we expect you to exchange motions and eliminate any potential voir dire questions as whether or not.
No one steal my idea, damn it. I thought of this first. You saw it here first, everybody.
Also, whether or not you want to do a panel voir dire, so that we can talk about it on the.
So those, and the dates that I gave you, November 16th and
we'll keep
January
doing
5th,
this
those are
here
out of
till the
court
next hearing.
dates. Have all your motions filed on those dates. And give me a realistic date that you all can file your pretrial conference report. I suggest it be around November 3rd. Maybe we'll do
Good.
November 3rd.
We'll come back on Wednesday night. I'm
Does
going to
November
take tomorrow
3rd actually
off.
work?
Can you do November 3rd?
Yeah, November 3 signed, Judge.
All right.
So that's just the final pretrial conference. And that's it.
Yes. So we currently do not have an in-person date until we see about those filing of motions from January 5th.
Does it make sense to have an in-person date of November 3rd, Your Honor?
It does if you want, but you've talked about the expenses. It doesn't make any sense to fly people out here if we need, if it's unnecessary.
My suggestion.
Real quick, Amber, thank you so much for the $30. Says, always enjoying listening to your streams. Wishing continued success in Free Karen Reed. Thank you. All right, we're almost done here. About another 5 minutes. So I'm going to wrap this up. I appreciate everybody checking out LTL tonight. You all have made a world of difference. And it looks like currently right now, Kelly Reed is at $30,522. Congratulations. And I'm so glad that I could give a $100 donation, $115 donation to get you up over the top. And tonight we will kick back the 25% of all the super chats, cash apps, and all that back to Karen Reed's defense fund and how I do it. You'll see it posted on the defense fund page. Say LTL chat raiser and the date 7/15/24. We'll put the total amount at the end, and then I'll post it up on the Facebook page and the YouTube community page. All right, let's finish out this 5 minutes. Thank you all for being here. I love all of you. Thank you.
My suggestion is that we would like to have a person here on November 3rd.
Okay.
Teeth need to be crossed, eyes need to be dotted.
I'm not available that day.
Okay.
That week, actually. I'm on trial.
Can we pick a date the next one?
$20. Thank you. Shock and
6,
horror.
7, 8,
$20. Thank you.
10, it says Veterans Day observed, but I don't know. No, Jim, let's do
Jim.
let's actually do the following week. Let's do the 16th.
Thank you for all the donos. I appreciate it. Helped Karen. Helped
November
Karen.
16th. Can you do November 16th?
And I'm sorry, that's for
Jim.
what event?
This next in court date. We can't do the 3rd.
Oh, you can't do the 3rd. I'm sorry. Okay.
The 16th.
That's the date that you're to file all non-evidentiary motions by anyway.
Yes.
So as of right now, 25% is 730. It's going to go 83 to Karen. 183 to Karen.
My counsel makes a
Thank
good
you.
point. Maybe
Appreciate
I'm
you
sorry.
being here. We are a week away. Yes. I will be
Okay,
there
I
on the
don't want to use that
22nd.
week.
I will be there.
Yeah.
Yes. Jim.
I was going to say, Your Honor, it may make sense to do it maybe a
I
couple of weeks
will be
later after
there.
we filed all the non-evidentiary motions. Could we potentially do December 1?
No, that's the Superior Court judge's business meeting. You can do the following week. You can do the 8th if you want a Friday.
Following week, the week of December 4th.
Let's do the 8th, Jim.
The
Friday?
8th. Do the 8th of December.
Yeah, the 8th works.
Fine. Is that okay?
Goodbye.
Goodbye.
Jimmy, that would be great. I can see you in a bit.
Tori, thank you very much.
Look at that love that team is. Jackson smiles. Love it. All right, we're going to finish this one out. Thank you for coming and watching this stream for the last 2 hours and 20 minutes. I appreciate it. Thank you all for being here. I will be back on Wednesday night. It's going to be a late show. It'll be 9 p.m. We'll probably play one of the shorter hearings. I want to play the Fed letter, when they got the 8 federal letters. It's about an hour long. So we'll go through that one. That one's very important as well. And if you all remember, what was the channel that broke the 8 federal letters online? Yes, it was LTL. We got to read them that night and read through them and break them on the internet. So that was a pretty exciting stream. So let me just finish this one out. Karen leaving the courtroom. And what do we have? What do we have for a total right now? Who's going to buy the order to get us over 50,000? How far away is the 50,000? Paul, how much do you need to get to 50,000? 730 total. Okay, we're at 730 total right now. 25% of that. You need 110. So let's just do this. 25% is 182. I'm going to do it to 183, and I'm going to donate that right now. Paul, if you can drop your link in the chat, I'll click on it, and I'll give you the 183 to get Karen over the 50,000. So let's do that tonight. Instead of doing it through the defense fund, I'll just donate it right through the popcorn sale. And I'll give that 183 to you, Paul. So drop your link in the chat. We'll do it. We'll do it that way. I'll wait for your link to come through. I'll give Paul back a little bit here because I've been kind of rusing him a little bit. All right. Oh shit, how am I going to do this? What's 115? Let's see, 115 plus 69 will get us 184. All right, I'm going to make 2 orders right now. I'm going to do one at 69 and one at 115. I'm not going to go off air until we complete this so everybody can see the transparency at the LTL business card. Let's make an order here. Everybody, my mom's going to be fat and happy with all this popcorn. All right, let's do the $69 one first. So let's do this. Let's do this. That's like almost perfect. You need like 180? Let's do that. Let's do this. So we're going to do this $69 one first. Hang with me, folks. Let's give that back. Okay. Let me just put in my card number. 8760 1489. Oh, what'd I do? $601489. Don't leave yet, Paul. I want to make sure you confirm that we got to the 50,000. All right, let's do this. All right, place the order on that. I wish I could just do PayPal. All right, so let's see. Just so everybody knows, I'm not going to post the receipts. I'll just do it this way. Be easier. Just so everybody knows. Let me just make sure it's transparent to everybody. So I did the order here. All right. And let me do one more and we'll get Karen over the 50,000. So I need what? I need to do one at 115. Okay. So I'll make sure I'm not showing my information here. I'm going to give Paul back this one. Hang on. Sorry, I can't see the screen right now. I can't see the screen, but I'm sure you're all saying good things. Okay. Let's do that. Let's do this. And my mom's going to be like, all this popcorn came. What is this? So I always send it to my mom's house. Right. Let me make one more donation here. 7. Paul, when I get this done, we'll refresh and you let me know if we get over 50,000. Should do it through this. All right. 140, 181. Let's place the order. Placing the order now. Order is placed. I'll show it for transparency. Orders placed, 127. Confirmed. Paul, let me know if you're still in the chat. Did we do it? Did we do it, Paul? Did we do it? I'll have him refresh and see if we got it. Let's see if we did it. Paul will let me know if he's still here. Let's make sure we get it. No, I know. I know. I just like to be transparent for everybody. Yes. Woohoo! We did it. Yeah. Yeah, baby. 50,000, baby. Thank you, Paul. Yeah, if no one is interested in popcorn, I just want to help out the competition a little bit. Let's do this. I'm going to drop Karen's defense fund in there. I appreciate you kicking, donations back to me. And I appreciate that. So, and I like to try to give 25% back to Karen. So we did it tonight. Awesome. We got over that 50,000, baby. Woo! Fucking right. I love it. That's so good. All right. 50,000. And we'll keep donating through this channel too. So everybody, thank you so much for coming in, watching LTL tonight. Let's Talk Live here on LTL Media Channel. I'm Brian. Make sure to like, share, and subscribe. And we'll keep fighting. We'll keep fighting, and we'll be back probably on Wednesday night, late Wednesday night. It's probably going to be a 9:00 show. And we will go through some more Karen Read hearings. So thank you all for being here. I love all of you. And please just free Karen Read. Keep the movement going. All right. I'm going to get out of here. Good night, everybody. Have a good night. Bye-bye.